Highland, Schwartzside, Orlando location. Okay, Bender Rembam, tell us a little bit about yourself and take it away, sir.
All right. Well, thanks as always to my esteemed colleague, Jeff, for that wonderful intro and for the information for everyone that wants to get the slides at the end of the presentation. I always welcome your surveys, whether they are good or bad. Fortunately, most of them are usually good and you pick the right class to be in. So welcome to the 2023 HOA board certification course. We will be talking about some of the legislation that has gone into place and that will go into place in October of this year that is brand new. So you're in the right place. That's why I always say that it's worth attending, even if you've already been to 1, 2, or 3 of these. Check one out every year, check out different law firms, although I would say that we've got enough variety within our firm that you might want to just stick with several of the attorneys that do present this class. So as to our firm, and as Jeff alluded to, I'm going to go ahead and explain who I am, what we do, etc. So I am the managing partner of our firm, K. Bender Rembam's Orlando office. We have offices in Pompano Beach, which is the main office, also in Palm Beach Gardens in Tampa, and then as well as Miami by appointment only. There are 20 attorneys at the firm. We are in the process of bringing on a couple more, but right now it's 20. We all practice almost exclusively in the area of community association law. I say almost because we do have one attorney who is board certified in construction law. 8 of the attorneys within the firm are board certified in this area of law, and we have several circuit and county court certified mediators as well, including me, who handle only community association disputes and mediation. So we're really happy to present this seminar for your education. A little bit of background on me. I've been with K. Bender Rembam before. As Jeff mentioned, I returned to the firm just about a year ago, but I was with KBR from 2010 to 2014, primarily in the area of collections. Since then, obviously, I've broadened my horizons. I do a little bit of everything at this point, but when clients hire us through our Orlando office and decide to work with K. Bender Rembam, I am 90% of the individuals who you will communicate with. So I generally make sure that all collection and litigation is moving forward the way that our clients want, although I have very, very little need for oversight because frankly, both of those departments do a fantastic job, and everything else that a community could want that is working with our firm will probably be working directly with me. So if your community ever needs any kind of legal representation, we hope you'll think of us. It's literally all we do, and it's what we do. So let me go ahead and share my screen and make sure that I'm sharing the correct screen. Let's see. Jeff, I think we should be good now. If you can confirm, it looks like it's loading. And
yeah, we're looking good.
All right, good. So this is my contact information. The easiest way to reach me is going to be via email. That way I get it no matter what time you're contacting me. I might not read it immediately, so be prepared for that, but it will come through. It's as@kbrlegal.com, and KBR Legal is our website. I strongly suggest that you check that website out. We've got tons of free educational options and information, including recordings of all of the classes like this and on other topics as well that we've done throughout the last few years. They're all available, and this one will be available as well within probably, Jeff, what do you think, the next few days, maybe next week?
Yeah, a couple of days. And I just want to reiterate, just remember, folks, if you plan to share this recording once it's online with any of your fellow board members, please know that the only way to get the certificate is to be watching this live. When it's on the website, all of the courses are there for informational purposes and review purposes only. They're not for on-demand CE credit reporting or on-demand certificates. You must be here live for that. But again, welcome to share it for informational purposes and for review, of course.
Always fun when the PR guy does the disclaimer. That's appreciated because your voice is probably a lot more pleasing than mine. Anyway, we're going to move a little fast now that we've gotten started. We have 150 plus slides to cover in 2 hours and a couple minutes, which means less than a minute each without Q&A. So the good news is, like Jeff mentioned, we will make these slides available. All you got to do is fill out your survey, and part of what you'll click to get your certificate, you'll also be able to get the slides at that time via, I think it's a PDF most likely. But without further ado, let's just go ahead and get to it. So starting out, why are we even here? Why do board members even want to take this class? Well, the reason is the statutes say there are two options. And when I say statutes at any time during this class, what I'm talking about are the Florida statutes in particular, most likely governing HOAs, which is Chapter 720, potentially also the nonprofit corporation statute, which we'll get into in a minute, which is Chapter 617 of the Florida statute. So back to what we were talking about. Association board member certification is required after 90 days after you're elected or appointed to the board. And excuse me, if you don't do that, then you are technically off the board. So you'll want to do this as soon as possible. Once you get on the board, you'll find a class like this. Tell all of your other directors to find a class like this, because the other option is you basically sign a piece of paper that certifies in writing to the secretary of the association. That'll most likely go to your property manager if you have one, but it's basically saying that that director has read the governing documents of the association, will work to uphold the documents and the association's policies to the best of their ability, and will faithfully discharge their fiduciary responsibility to the association's members. Now, I would say in 75% or more of instances, when someone signs that piece of paper, they have no idea what the governing documents say, no idea what the Florida statutes say, and they don't even know what that fiduciary responsibility that we mentioned in the slide even is. Well, that's why you come to a class like this instead, which is option number 2. And in my opinion, it is the far better option. You get a curriculum that is taught to you, you get educated, and hopefully you'll walk away today with a better understanding of how to be a good board member and hopefully how to be a good officer of the community as well. You'll also understand what your obligation to the members is and what your obligation to the community is. Okay, so basically 2 options, you chose the right one. Okay, because let's be honest, yes, you can certify that you've read the documents, but they are mostly poorly drafted unless we've amended them at some point. They conflict internally, they conflict with other documents, they conflict with the Florida statutes, they're written intentionally or unintentionally vaguely. In other words, they could be interpreted in multiple different ways. And you really want to make sure that this is a document that you understand if you're going to be the one that's saying, yep, I've read it and I'll do my best to do what it says I'm supposed to do. Well, if it's not clear, how do you even know what you're supposed to do? Okay, so come to this class. Great call. And I mention that not because I'm trying to get you guys to show up. You're already here. But I want to make sure you understand that all of your other directors should be coming to the next time that I teach this class in 2 months, or someone else within your within our firm is teaching it possibly sooner for HOAs. All right, board member certification doesn't have to be repeated. And one thing that I think is on the last slide, but I didn't mention, you can do this certification up to a year in advance of serving on the board, and it's still valid for that service. So if you take it before, that's great. Just make sure that you keep your certificate. If you're not yet on the board, but you intend to be in the future, keep that certificate, hand it over to your secretary once you get on the board. Fantastic. Now, what this slide says is you won't have to take this class again, although I'd recommend it anyway, as long as you stay on the board without interruption. Now, there are 2 different ways that you could look at what that interruption means. It doesn't mean that you were suspended, that you were suspended from serving on the board. What I mean by suspended is you're technically off until you do something and then you're automatically back in, okay? What we mean by without interruption is if you resign, if you are removed from the board by a recall, or if something happens that you are required to be removed from the board. For example, you end up, too far delinquent in your assessments or some other monetary obligation, and the statutes say you're out. Well, if you come back on, let's say you pay off that debt, you get reappointed to the board, then you still need to take a new class. Okay, but if it's just a suspension, you don't need to do it. That written certification, that certificate that you'll get after you complete the survey at the end of this class, needs to be kept in the association's records for 5 years after the director is elected or appointed, or the duration of the director's uninterrupted tenure, whichever's longer. In other words, if you serve for 15 years, you technically don't have to take this class again. However, think about how much the law is going to change within those 15 years. So my suggestion, take this once a year. If you don't have the written certification or your educational certificate, meaning you signed the piece of paper or we gave you one via our website, if that's not on file, it doesn't affect the validity of any board action, but it does mean that director is technically suspended automatically and without the board making that decision. It's automatic until that certificate is placed in the association's records.
Alan, for a quick water break, would you recommend, you mentioned taking this at least once a year, even if you don't need it. How would you respond to perhaps taking it after anytime there's a legislative session? You know, that might be more than once a year. It might be a good idea to do it anytime they're aware of a session, correct?
Yeah, I think it's a good idea to do that, especially if you're following along with Rembaum's Roundup or our other legal update emails. And you've seen that there has been a legislative update pertaining to an HOA, you know, that, for example, Jeff's email, I think, went out in either May or June saying what we think is on the table that's going to be changed in the legislature. After that happens, you'll definitely want to take another class, whether it's, you know, around this time of year or there are some changes that won't go into effect until October. We'll be able to tell you about that stuff a little bit in advance, for example, now. So yes, I think it's a good idea. Anytime there is a legislative update, take that class. And if you don't see any legislative updates, for example, you know, there may be very minimal changes to the HOA statutes because everyone was focused on condos like last year. Okay. I'd still take the class every year, even if there's no major changes, because you might get different insight that, frankly, even if you're with me and take my class every year, I've gained different insights over the course of that year that I can then translate over to this HOA class and to my condo class as well. And then again, you know, taking it with different attorneys, you're going to get a different perspective. Taking it with different firms, you'll get a different perspective. Okay. Obviously, ours is going to be the best class you'll ever get, but that doesn't mean that you can't still go out and take another attorney's classes. I know people that do 3 attorneys classes, even though they work with us no matter what. Okay. Not necessarily something I'd recommend, but it is something that people do. So HOAs in general, we'll talk about a lot of this later. And fortunately, it's one of the things that we can skip. So we're gonna, because we still have a lot of slides left. Let's see. Okay, Florida statutes, I mentioned chapter 720 governs Florida homeowners associations. Keep in mind, this statute was created after a lot of the declarations, a lot of the communities in Florida were created. And as a result, we're going to get into it a little bit later when we talk about which year's statutes apply, but there is a constitutional right, both under the Florida and United States constitutions, to keep contractual rights as they were initially intended. And so a lot of these declarations predate the statute. So we'll talk about it later, but I want you to understand, it's not just you look at the statutes, you ignore the governing documents of the association. It's never that simple. And your attorney might need to guide you through it, but we'll talk about how in just a minute. But bottom line, Chapter 720 was created to basically give statutory recognition to residential communities such as HOAs, property owners associations that are not condos, etc. This does not govern, just to be clear, any condominium association, cooperative association, or mobile home community that might be governed separately. And I have seen some that are mobile home communities governed by both statutes. I've seen master HOAs that govern a bunch of condo buildings. Just keep in mind, when I'm saying this, it's as a general proposition. If a building or a community is subject to a different statute because it's a condo co-op or mobile home park, it's not going to be subject to 720 necessarily. So just be careful how you're trying to apply those statutes and run any of those questions by your attorney to make sure that they've at least once given you the confirmation that you are subject to Chapter 720. Now, every community association in Florida, other than some of the commercial communities that I'm aware of, every residential community that I know of is subject to Chapter 617. That's the not-for-profit corporation statute. A lot of attorneys somehow don't even know that this is still something that governs Florida HOAs. So just be aware that the Not-for-Profit Act used to be the only one that existed that governed how an HOA corporation was supposed to operate. But now we have Chapter 720 as well. Any conflicts between those two chapters, you're going to look at Chapter 720 first, because that's the one that's more specifically governing your type of community. So I mentioned you want to know what year's statutes apply, not just do the statutes apply or the governing documents. So the substantive law that was in effect at the time a contract was made, and your declaration is a contract, by the way, between your community, the corporation itself, and every member, every resident, everyone within that community. That contract, the declaration, the substantive law that existed when that was entered, usually when it's recorded, is grafted into the contract as though it was actually written. So that entire chapter 720, if it existed at the time, it's like whatever statutes were in place at that time are part of your declaration, unless you've got something that comes along later and changes it. So I mentioned your constitutional right to avoid anything that changes in a statute that adversely affects or destroys a vested right, meaning substantive rights. And substantive means substance, just for anyone that doesn't know that term. It imposes or creates a new obligation or duty in connection with a previous transaction, or imposes new penalties. Now, the new penalties could be statutory fines, things of that nature, okay? So this is what Kaufman language is. You might have a declaration that automatically incorporates all changes, regardless of whether they're substantive or not, regardless of this constitutional protection. There's language that can be included in a declaration that basically says, we don't care about any of that. We want the statutes as they exist from time to time to be applicable to our community, because sometimes there are better protections for HOAs in the new version of the statute. Usually it's more protection for the owners, but you never know. Okay, so in this instance, if the declaration says that it's subject to the Florida statutes without any more language, then the analysis that I just mentioned, where the statutes that were in place will likely, as of the recording of the declaration, will likely apply as to substantive issues. We'll get into what that is later, okay? If this language is in here that's in purple and bold, if it says that if the declaration says that it's subject to the Florida statutes as amended from time to time, then every legislative change will apply to your community, regardless of whether it's substantive or procedural, okay? If you don't have this language, then you start with the question, does the legislation itself provide guidance as to whether it's retroactive or it only applies in the future? If it says it only applies in the future, okay, we don't have to worry about it. It only applies in the future. If not, if the statute's not clear, are the changes substantive? Meaning, do they change a substantial substantive right? And when I say substantial, I don't mean a big right. I mean a vested right that the owners in your community have as of the date that the amendment goes into effect. Or is the change to the procedure that you're going to follow in sending notices, things of that nature? Okay, if it's procedural, the legislation is still probably going to apply because this doesn't impact a substantive right. If it's substantive and you don't have this Kaufman language, chances are your declaration or your bylaws, whichever the governing document is, are still going to govern your community. Procedural laws provide means and methods for application and enforcement of existing duties and rights. Pardon me, I might take more water breaks than normal because I still need to talk fast, but I'm just getting over an allergy attack. So please accept my apologies if I do need a break here and there. Substantive laws are going to talk about legal duties and rights. And once those rights and duties are vested, meaning they exist now, not they're going to jump into existence in the future, due process rights prevent the legislature from retroactively saying you no longer have that right. Okay, so a few examples of substantive rights are the ones that are listed here: ownership and common expenses and surplus, your right to use common areas, a cause of action once you're actually able to file a lawsuit, etc. Okay, if there's a conflict between the declaration, articles, and bylaws, what do? Well, it's actually pretty straightforward. Okay, just remember the old expression, a little dab will do you. Okay, the declaration, and I'm going to go through what each one of these are, but they're listed here in order of importance and in order of control. So if you've got a conflict between the declaration and any other document the declaration controls, if your conflict is between the articles and the bylaws, the articles control. If it's between the articles and the declaration, the declaration will still control, like I said. And then again, if there's a conflict between anything in the bylaws other than your rules and regulations, your policies and procedures that are not part of the declaration, the articles, or the bylaws, then the other document will control over the bylaws. Okay, so again, you're going to go declaration, article, bylaws in that order. Now, what are these things? Your declaration, I've mentioned the word a couple times. They're your CC&Rs, your covenants, conditions, restrictions, easements, etc. I don't care what it's called, but it's basically the document that is like the constitution of your community. It's the contract that binds the members. It runs with the entire property that's governed by the HOA. Anything that's in this declaration is basically going to be presumed valid by a judge unless it's enforced arbitrarily or it's illegal under case law. Okay, so one example of that type of illegal provision, the statutes were changed a couple of years ago to basically say you can't have anything that says a certain race, religion, etc. can't reside in your community. Makes sense. Okay, I actually explained during a recent webinar that I gave that I was part and very proud of removing a set of restrictions that said no blacks or Jews may live in our community. I was pretty proud of removing that. Okay, but that is something that wouldn't have been enforceable anyway, but the board was so fed up with it even being in the governing documents that they wanted to remove it. I was very proud to have done that. The Articles of Incorporation is the next document that basically says the name and purpose of the corporation that's going to operate and maintain your community. And then the bylaws, most people think that this controls the day-to-day operation. That's really going to be your declaration. What the bylaws really control are how meetings are run, your directors and officers' duties, how they're elected, etc. And then finally, you've got rules and regulations, which encompasses pretty much everything else, your architectural criteria, your policies and procedures, your actual rules and regulations. These are generally going to be board made. Everything else, most of the time, is going to be voted on by the entire membership if there are going to be amendments to the declaration, articles, or bylaws. This is generally going to be made by the board. These rules are just voted on by the board at a board meeting and made without member approval, which means that they're scrutinized really closely by the courts. So there is a specific test. We don't need to get into it today, but if you are questioning whether one of the rules and regulations of your community are valid, ask your attorney to go through the full analysis of determining, is it reasonable? Is it blah, blah, blah. So, and yes, blah, blah, blah is a legal term. Moving on. Transfer fees and estoppel certificates are the next thing we're going to talk about. Transfer fee covenants are against public policy because the public policy of the state of Florida is to make it as easy as possible to transfer ownership or rent your property. That does not mean that they are not allowed. Okay, so these covenants that say it's harder to sell, harder to rent your property, they're allowed. Okay. You should generally be able to do what you want with your property, but you live in an HOA and there are restrictions because people want this community to be what they initially bought into. They don't want it to turn into a completely different community. When I say that, again, I'm not talking about race. I'm not talking about quality of human beings. What I'm talking about is, do you want to be able to sell to someone who's going to paint their house pink with purple polka dots? Okay. Do you want to sell to someone who doesn't understand or care that there are covenants that everyone else in the community is following? Okay. So part of that is that the state basically says, well, we don't like transfer fees, but these things are not transfer fees. Okay. Any charge payable to the association pursuant to the declaration or a covenant or law that applies to the association, including fees or charges payable for estoppel letters or certificates that are issued by the association or its authorized agent. We'll get into what an estoppel letter is later on, but an estoppel fee is an allowed fee, even though it's technically affiliated with a transfer. Okay. Actually, that's the next slide, I think. So is any fee payable to a nonprofit or charitable organization for certain activities that benefit the association if the declaration authorizes it. So again, some of these things, it may need to be included in a covenant, not just your rules and regulations, not just a resolution of the board. Generally speaking, the transfer fees that we're talking about are, well, we're going to charge $20,000 every time someone buys into the community. I don't know that that's necessarily reasonable, whether it's necessary, but if it's in your declaration, it may be enforceable. But if it's not in your declaration, you definitely can't charge it. Moving on. What is an estoppel certificate? See, I was right. Within 10 business days after receiving a request for an estoppel certificate from an owner or mortgagee or either of their designees, meaning someone that they say is entitled to that information and can request it from the association must issue the estoppel certificate. Again, 10 business days, okay, not calendar days, but it's still not a lot of time to get this done, especially if you've got an account that's in collection with your attorney or an enforcement matter that's with your attorney, and they need to do some kind of calculations as to what is owed or what is going to be included for attorney's fees, costs that have been incurred, or if they need to update their calculation of what's owed on the account. The association must designate on its website, if you're required to have one, a person or entity with a street or email address for receipt of the estoppel certificate requests. In other words, you need to tell everyone where to send these requests. Otherwise, people are just going to send it to management without knowing if it's going to the right department or person, or they're going to send it to someone that's on the board but has nothing to do with this. Okay, so you want to designate that person, whether it's in some kind of policy somewhere, or if you have a website, preferably on that website. The certificates must be completed by a board member, authorized agent, which could be your management, could be your attorney, whoever it may be, or authorized representative of the association, including any authorized employee or agent or representative of the management firm. Okay, so basically, this is what you need to do when you get this request in. You need to have one of these people complete the form that these people are sending over. And if they don't send one over, there is a statutory form that we've prepared and can be provided to the association for minimal cost. And it's just a form that you use indefinitely unless and until the statutes change as to what needs to be included in the certificate. So let's talk about what does need to be included. What even is this estoppel certificate? It's basically a document that says what's due and a bunch of other information about violations and other things that's required by statute. We'll go through what those things are, or at least I'll tell you what the slide is. But it basically says, hey, we're telling you everything that needs to be done for this new owner that's coming in trying to buy this property to come in with a truly clean slate. They won't owe anything. They won't have to change anything on the property. There are no architectural applications that were never submitted but should have been. Basically, if it's not included on this document, it's not something the association gets to go after the new owner for. Now, this may be something that's also requested in conjunction with a refinance of a mortgage, HELOC, whatever it may be. And I had someone ask me what a HELOC is the other day. It's an equity line of credit for a home. But bottom line, this is a document that says, here's what you need to do to start with a clean slate once this transaction closes. And we're acknowledging, and so is the statute, is saying that anything that's not included here, we don't get to do, we don't get to collect, we don't get to enforce. So make sure that everything that is asked about on that certificate, presuming it's something you're obligated to provide to these people that are requesting it, is actually provided, because you may be out of luck if it's not included on this document. As a practical tip, if an account's in collection, don't state what's on the ledger as the balance, okay? Any attorney's fees and costs, especially if you're under our firm's collection program, you probably haven't been paying any fees and costs. You haven't seen a bill for any fees and costs until we close out the file. And so you have no idea what bill you might end up with if that becomes uncollectible because you didn't ask us what we've incurred. You didn't ask us to help out by providing the payoff, which is something that I recommend that all management firms, all communities that are self-managed, when you get this request, if an account's in collection, make sure that the portion that you are filling out regarding the existing debt, make sure that that is filled out by saying, see attached payoff letter, and having your attorney prepare a payoff that's updated. Because anything that's not included, including those attorney's fees and costs, could be late fees and interest that the association hadn't been calculating, but the attorney noted was in your governing documents and included. You might be giving up a whole bunch of money and coming out of pocket a whole bunch of money if those attorney's fees and costs are written off. So it's crucial to handle these appropriately, because it really does cut off your ability to do anything that's not included in this letter. And I know we've spent a couple minutes on it, but it's extremely important to get this right. It's also crucial to handle it as soon as possible, given the time frame supplied. It may take a day or 2 or 5 for the attorney to get this document prepared and get an updated ledger from you so that an updated payoff can be prepared. So make sure that you're getting this done and getting the information over to the attorney right away if that attorney is working on anything for the association regarding that particular lot. They need to be signed by an officer or authorized agent of the association, and they can be provided by hand delivery, regular mail, or email on the date that that certificate is issued. So moving on, here's what the statute says needs to be in here. General information, and again, pardon me, you'll get the slides. We don't need to go through the detail of what it entails. And frankly, we just don't have the time to do that with a 2.5-hour total class with 153 slides total. But you'll have the information if you complete your survey. And then there's some other information that goes into it as well, so you can read through this later. There are fees that can be charged. That is $2.99 if on the date of the certificate is being issued, there is no delinquent amount owed to the association for that lot. If there is a delinquency, you get to charge another $150. If they request it on an expedited basis and you actually produce the certificate within 3 business days after the request is made, you can charge another $119. And you do need to have a resolution of the board put on or have a management agreement that was actually approved by the board that provides for these fees being charged by management in order to charge these fees to the person that's requesting them. So just keep that in mind. You might not have that in the association's records, and if not, you might not have the authority to actually charge these fees. If you don't have that, we'll get into what notice is required for a board meeting later, but honestly, it's 48 hours posted notice. Have a board meeting, have that resolution drawn up and signed, and be done with it. That way you don't have to worry about whether you can charge it or not. And by the way, I mean do that now, regardless of whether you've ever gotten a request for an estoppel certificate or not, because then you won't have to scramble to get it done within the 10 business days that you have in the future. If it's delivered late, you can't charge any fees for preparation or delivery. So you might be losing out on potentially almost $1,000 in these fees. The other practical tip, I've seen owners claiming that if an estoppel is wrong or isn't provided in time, oh, we lost the sale and we're going to sue the association for the lost profit or the cost of maintaining the lot for another 3 months until we find another buyer who's ready to move forward. So just keep in mind, you want to make sure to provide these within the time provided and make sure that they're accurate. Now, there are charges that apply if there are multiple parcels included. So if it's anything under 25, you've got a $750 fee. Anything up to more than 100, you've got separate fees for. So just be aware if there's more than one lot included, you've got specific fees instead of the $2.99 that I mentioned in the previous slide. Now, another thing that some attorneys don't even seem to know about, but a lot of managers also don't know, if someone requests a refund of that estoppel fee within 30 days after the transaction is canceled, in other words, after the closing was supposed to occur but didn't, you need to return those funds, whether it's the $2.99 or even the close to $1,000. You need to return those funds to whoever paid them within 30 days after you receive that request. Now, you're not out that money. You did the work and you've earned the fee. So the estoppel fee then just gets tacked on to the account. Now, the way I read this statute is that it gets tacked on as an assessment. Some people put it on as a cost just to avoid the risk of some judge finding that it's not an assessment. I don't really have a problem doing it either way. But there is a statutory entitlement to attorney's fees and costs for anyone that wins a case about failure to return those funds, failure to produce the estoppel, etc. So you want to be careful, or failure to provide an accurate estoppel. So again, make sure you provide it, make sure it's accurate. And if someone requests that refund and verifies that the transaction was in fact canceled within the last 30 days before they request it, you've got 30 days to get it back to them. These are all calendar days, unlike the 10 business days provided to actually produce the estoppel in the first place. Now, the fees that I've mentioned so far were updated in July of last year. So I don't expect an increase for at least the next 4 years, because it's supposed to be updated every 5 years. So just expect that the fees that we mentioned in the slides as a maximum are going to be the maximum for a little while now. Okay, these estoppel certificates are good for 30 days, meaning that anything that's coming due in the next 30 days should also be included on the estoppel certificate, not just the past due balance as of today that we're issuing this. It's good for 35 days instead if it's sent by mail to the requester. I don't know of anyone that actually mails these out. It's always either faxed, which is even more antiquated in my view, or it's emailed out. I also don't know anyone that does hand delivery, but that is an option. Anything other than mail is 30 days. If it's mailed, it's 35. Keep in mind also, if you make a mistake that you notice later on, or that the owner brings up and you say, oh my gosh, they're right. Or if new information allows you to amend the estoppel, for example, they make a payment and you got to apply that so that you have an updated debt figure. You do need to amend your estoppel. You can do that at any time before the transaction happens. So if you realize, oh my gosh, there was a violation and someone just pointed it out, we got to add that in because we didn't know about it before. But now that we know about it, we'll be completely out of luck if we decide not to include it. You amend, you update the good through date to 30 to 35 days after the date of the amended estoppel certificate. And you can't charge for the amendment, but you can issue it. Okay, so you send that out. Now you've got an updated estoppel certificate good for 30 or 35 days as applicable. And you know that everything that needed to be covered is covered. There's other information that can be requested. You can charge up to $150 plus the reasonable cost of copies and attorney's fees in responding to requests for information from prospective purchasers, lien holders, etc. that is not an estoppel certificate. Okay, Fannie Mae, Freddie Mac, some of these other lenders are asking for this type of information now. The other thing we point out, which doesn't necessarily impact the association, unless the association is the one selling the property, that the seller has a duty to provide the buyer notice of all hidden defects. In other words, the ones that you can't walk in and see, oh, there's no wall here that there should be. Things that are not obvious are the things that you need to disclose to the purchaser. All right, another water break. And then we can move on to use right suspensions, voting suspensions, and fining. We'll get into these in just a moment. Fines and use right suspensions for everything but failing to pay monetary obligations, because there's a big difference between failing to pay and failing to comply with the governing documents in general. You can fine or suspend use rights in this respect. In other words, for non-monetary violations, after following this procedure. So basically the board has a meeting and votes to levy the fine or the suspension. 14 days notice of a hearing before a separate impartial committee is then provided. Okay, the association, now I believe the statute changed this year. There used to be some question among attorneys as to whether or not you needed to hold that meeting or just offer that hearing before the separate impartial committee. Now it's clear you do need to actually hold that meeting. So even if the owner doesn't show up, you still need to physically have that at least 3-member panel available, and those 3 members of the fining committee, suspension committee, violation committee, whatever you want to call it, need to be non-directors, non-officers, non-managers, non-employees of the association, and not any of their immediate family members. In other words, it's not children, spouses, parents, siblings. I think that's pretty much it. So this fining committee needs to be embodied before you can suspend, before you can fine for non-monetary violations of the governing documents. If this finding committee doesn't say, yep, you know what, we've heard the evidence, we still think that this was something that violates the governing documents. If that finding committee says no fine or suspension, sorry, but the board can't levy the fine, can't suspend the use rights. If they approve, it takes effect immediately and the board will give the notice that it's been approved. In other words, that there was a fine levied against the owner and that a suspension was levied against the owner. Now, when I say suspension, what I mean is suspending the right to use certain common area facilities. Usually this is going to be your pool, it's going to be your basketball court, tennis court, whatever you may have, your gym. And to some extent, it might also be the right to use a key fob instead of having to go to a gate or punch in a code at the gate if you've got one. That one tends to be extremely valuable and useful because as soon as the significant other, the spouse, the tenant goes to that gate and their fob doesn't work anymore and they have to back up and go, even though they've gotten notice, of course, they didn't realize that that was real. As soon as they have to actually go to the gate and give their ID or whatever is required of visitors, that violation is going to be cured real quick. I've very rarely seen that be ineffective to get a violation cured. Now, fines for everything but failing to pay monetary obligations. In other words, non-monetary violations. We talked about what the impartial committee needs to be comprised of. We didn't mention the fine can't exceed $100 per violation unless the governing documents say otherwise, and it can be levied on the basis of each day of a continuing violation, but not more than 1,000 per violation in the aggregate, meaning combined for those 10 days, unless the governing documents say so. Now, as of now, I know that there's been a push legislatively to change this, but the statutes do allow that a fine of $1,000 or more can become a lien against a parcel collected like an assessment through the lien foreclosure process if the governing documents say so. Okay, so I don't really like that. I think that it's something that, listen, it's a right that the association has. I'm never going to, let's say, vote in favor of removing a right of the association to go after its owners for non-payment, for violations. However, I do think that it's a little silly for the association to be able to foreclose someone's home because they didn't weed the driveway, for example, because that could very easily be one of the violations that is ongoing, results in a violation, results in a fine, and is not cured within whatever time is given for that $1,000 to accrue and the foreclosure to be appropriate. So if someone doesn't pay that, they should lose their home because they didn't weed their crack between the sidewalk and the driveway. I don't agree with that, but that's what the law says as of now. By the way, I also don't like fines unless your intent as a board is to actually file a lawsuit to collect those fines. Because if you're sitting there and telling someone you owe us $1,000, but we're not going to foreclose, we're not going to file a lawsuit to collect that $1,000, and when an estoppel certificate goes out because you're trying to refinance your home, that's the first thing that the board is going to waive. What does that do to the board's credibility? Kills it. Okay, people stop taking the board seriously and say, well, you're not going to follow through on this, so what do I care if I get fined? I'm not even going to show up to the finding committee meeting. Okay, if you're going to follow through on it, bravo, have at it. But my opinion has always been that the customary and general enforcement process, which we'll get into what that is later, is definitely the better option. I don't have a problem with using the two in conjunction with each other, though. Okay. A fine is due 5 days after the date of the committee meeting when the fine's approved. So you do have to give notice, but that notice can be mailed out and the fine is due almost immediately after that notice is received. Okay, use right suspensions for failing to pay monetary obligations for more than 90 days. So again, now we're talking about monetary, not just a covenant violation. The board can suspend the right of an owner or anyone else that's using the property to use common elements, common facilities. And when I say common elements, what we really mean is common areas, which is the HOA term, or any other association property if the owner is more than 90 days delinquent in any monetary obligation. That could be a fine, It could be a keying charge, whatever it may be. It doesn't necessarily have to be assessments that are due to the association. Okay. Any monetary obligation. All you need to do is have the board vote to suspend those use rights, and that's it. Again, this is only for monetary obligations that are greater than 90 days. Now, the condo statute was recently changed. I wouldn't be surprised if we see a similar change in the future for the HOA statute that says that this minimum, this obligation needs to exceed $1,000 in order for the association to suspend some of these rights and do some of the things that we're talking about. That is not the case in HOA land as of now. So if it's $5 and that's all we're talking about, sorry, thought I put that on mute. If the debt is $5, doesn't matter. You can still suspend the use rights because of it. Okay, for the use right suspension to take effect, they need to notice whoever they are potentially suspending of the upcoming meeting before they do it. Okay, the use right suspension is effective until all the monetary obligations are paid in full, and that motion can be done one time for multiple properties if it's done at a properly noticed board meeting. You might not want to do that because you might want to give the opportunity for each one of these owners to be aware that this is coming down the pike, and also to argue against it and be able to say, well, you had your day in court, so to speak, so that when you end up in court in reality, you can explain to the judge, listen, we gave them every opportunity to resolve this. They just chose not to do what they were supposed to do. Because let's be realistic, a lot of what we're talking about today is intended to make sure that the association, which is inevitably going to be looked at as the big bad guy in a lot of judges' views, even though it's completely wrong, a lot of judges view us that way. And when I say us, I include the attorneys representing HOAs. You want to be able to present to a judge, we did everything we could to try to work this out before we wasted your time with this ridiculous issue that this owner is allowing to go on forever. Okay. And frankly, there are a lot of times that I will present to a judge that way. Judge, I know it's ridiculous that we're here today, but unfortunately, we're in a situation where the governing documents are clear that they don't allow or require XYZ on this owner's property. We've notified them 15 times that they have to comply, and they just aren't doing what they know they're supposed to do. When you put it that way, and when you give your attorney the opportunity to put it that way, judges tend to understand a little better that you're not the big bad guy. You're just trying to get a situation where the owner has done what they are legally obligated to do. So the suspensions of these use rights, whether for monetary or non-monetary violations, do not apply, and this is important. You cannot suspend the right to use common areas that are used to provide access to the parcel, meaning you can't block the roads off so that they can't use it, or utility services to the parcel if the utility services are something you're providing or that they have access to. And you also can't prohibit vehicular and pedestrian ingress to and egress from the parcel, including the right to park. So you can't block off parking spots and say you can't park in your designated parking spot. You can't say you can't drive or walk into the community anymore. All you can suspend is the right to use amenities. Jeff, you had something to add?
Yeah, and a little water break for you. This question comes up quite a bit. Let's say the HOA, and this will work for condos too, but this is an HOA class, has a bulk cable contract. Is that considered a common use amenity because everybody contributes to it? And can the HOA stop somebody from viewing their TV via the bulk contract?
Generally, it's questionable at best, in my opinion, as to whether or not that's something that the association can restrict. I would say internet even more, if it's part of that bulk contract, is something you probably should not restrict, because the question is whether that counts as a utility. And I think that a lot of people will argue that it does. I frankly have cautioned my communities that doing that and suspending those rights is a risk. And as a result, frankly, I haven't had to bring that issue before a court. I'm sure there are plenty of attorneys within our firm that have, but I've never seen a particular ruling, and especially one that would be binding on any court that might rule on these issues for your particular communities, that is said, we have to rule this way. We have to say that is a utility and you can't suspend it. Okay. So again, internet, cable TV, the statute doesn't really clarify, but I think that there is some risk to just shutting that off for an owner. And especially if the owner is paying separately for cable, even though you have a bulk subscription, you absolutely shouldn't be cutting that off for them.
And I certainly didn't mean to stump you. I just wanted to bring it up because it is a risky thing, and some people rely on that as their only means of telephone service. And if there's an emergency in the unit, it's just not something you probably want to drag your association into.
Agreed.
Okay, back to you, sir.
All right. So the other thing you can suspend, not just use rights, you don't only have the right to fine and suspend use rights. You can also suspend voting rights if someone is not paying their monetary obligations for more than 90 days. So you're basically having the board, in the same way that you would suspend use rights, let the owners know via the notice of the upcoming meeting, which, by the way, one of the other statutory changes for board meetings is that as of October 1st, it might already be in place, but I think it's October 1st. Every board meeting, every member meeting needs to be met with an agenda in an HOA. It's been required in condos for a little while. Now it's also statutorily required in an HOA. And back to what we were talking about earlier, this is a procedural change, which means that regardless of when your declaration was recorded, regardless of whether you've got that Kaufman language in it, that as amended from time to time language, you will have to comply with this. So what I would suggest, and have for a long time, is make sure that when you have a board meeting or a member meeting coming up, you actually have an agenda for it. That also will limit what can be discussed during that meeting so that no one can hijack it. Okay. We'll get a little deeper into that in a minute. If the owner is more than 90 days delinquent, you can suspend voting rights. Keep in mind that suspension, just like the other suspension, is in effect until that monetary obligation is paid in full. There is a condo case that says that this only applies because voting is a vested substantive right, that you might need to have this right in your declaration or have Kaufman language. I think it's more procedural. I think that you can probably include this as a remedy available to the association, but keep in mind that there is condo case law out there that says you might not be able to, absent that Kaufman language or language in the declaration saying, hey, if your declaration was recorded before the amendment that says you can suspend suspend voting rights, you may need to have an amendment to your declaration that allows you to do this. If voting rights were suspended, be careful what you wish for, because that won't count towards any vote that you get going forward. So it doesn't count, that voting interest won't be counted towards a quorum. It won't be counted towards an approval or rejection of a proposed amendment, changes to what you want to do with your reserves if you have any, etc. It just doesn't vote, and you've suspended that right. So if a vote comes during that suspension, that vote doesn't exist anymore, at least for purposes of that particular ballot. Moving forward, member meetings, we're starting to move along a little bit. One thing I also didn't mention, when someone violates in a monetary manner, in other words, they haven't paid their assessments for a while, but they're renting their property. If it's not a short-term lease, which you won't really be able to do this, if it's longer term, more like I would say 2 to 3 months at minimum, you can send a demand that the tenant pay their rent to the association directly going forward until you report back that monetary obligation has been resolved. The tenant is protected from being evicted by the Florida statutes that allow you to do this. And it basically says, you can send a notice in a form provided by the statute, which will usually prepare for the associations that use it with that work with us. And it basically says, you don't have to pay us if you've already prepaid your rent, but the next installment, the next payment you would have made to your landlord, you make it to us instead. And if you don't, we have the right to evict you. All right, moving forward, annual member meetings. Your bylaws are generally going to say how, where, and when these are supposed to be called. It's basically where you have your election. Okay. Your special member meetings can be held at any time based on a request of the members. It's pretty much anything other than your annual meeting that is a meeting of the members. Sometimes you'll do that for purposes of passing an amendment that you didn't want to wait until the end of the year to try and get through. You can do it for many other reasons that we'll talk about later. When it's called by the board or upon a request of at least 10% of all the owners is when you need to hold this type of special meeting, unless your governing documents provide a different percentage. Okay, when you're sending notices, again, it's the, I'm sorry, it's not again. Another statutory change that I have in my notes here that's coming down the pike on October 1st. It's been the law for a while, and my opinion for a while, that it's the owner's obligation to notify the association if they have a different mailing address. In other words, they've never lived at this property or they moved out, but they're renting it. Okay. If they didn't provide a separate mailing address, that's not the association's fault. It's not the association's burden to go into the property records every time they want to send out a notice and make sure that the property appraiser's website hasn't been updated with a different mailing address for these particular owners. They send it to whatever mailing and email address that owner has provided to the association. If none's been provided, it just goes to the property and that's it. Whether it's in the closing package or not doesn't matter to me, okay? Because let's be realistic, the association doesn't get that closing package. So making that argument, which I've seen several owners do even recently, well, you know, the address is on my deed. Why aren't you sending it there? Because you never told me you actually live there. Why would I send it? So again, the change is that as of October 1st, an owner has the obligation, not the association, to go out and look for it. The owner has the obligation to say, this is my new mailing address. Okay, notices and agendas. Again, written notice of this meeting must be mailed, hand delivered, or electronically transmitted to every member. In other words, members are entitled to at least 14 days notice of each one of these meetings. An affidavit by the person providing the notice needs to be prepared and saved in the association's official records to prove as evidence that everyone got notice of this meeting and what notice was given, how it was provided, etc. If the governing documents don't say otherwise, the annual meeting notice doesn't need to say what will be discussed at the meeting. Every other meeting notice really does. Okay, that's, again, as of, it looks like October 1st, the association is going to need an agenda for every meeting of the association except the annual meeting. Special meeting notices need to specify exactly what the meeting is intended to discuss and address, what's going to be voted upon, etc. And then there are other issues such as special assessments that might require special notices as well. Like a special assessment notice, meeting notice needs to specify that a special assessment is going to be considered, what the dollar figures being contemplated are for that special assessment, and what the nature of the assessment is. Are we redoing the clubhouse? What is this special assessment intended to cover? Keep in mind, when you talk about electronic notices, that means email, fax, teletype, I don't know, whatever. Any electronic notice is only allowed if the member actually consented to it. So if your response to, did you give notice of this meeting, is, yes, we sent out an e-blast, that may not be enough. You may still need to send it for mailing purposes. Now, keep in mind, electronic notices generally can't be used for recall purposes. So that still needs to be hand delivery or mail. Member meetings need to be held in a handicapped accessible location if anyone who has a handicap has requested it. So we're not going to get in depth about the Fair Housing Act and things of that nature. We do have one about pets that you might want to check out. There's also really good guidance from HUD, which is the U.S. Department of Housing and Urban Development, as to how they evaluate requests for an accommodation, which is basically saying, hey, association, I can't use your property the same way as everyone else because of a handicap or a disability that I have. So you need to help me be able to use the property the same way as everyone else. And the association, in most instances, will need to do that. We won't get into detail about that, but if you have someone that says, I have X, and as a result, I need you to allow me to Y, send that to your attorney immediately, because you don't want to screw those types of ADA and fair housing issues up. You want to get them right and not get sued for discrimination. Moving on. back to member meetings, quorums and decisions. A quorum is 30% of the members unless the governing documents and specifically the bylaws say otherwise. Pretty simple. Member decisions generally require a majority of votes during a meeting at which a quorum is present. There are some that will require a higher vote. Most of them only require a majority of a quorum. And when I say a majority of a quorum, what I mean is, let's say you've got a 30% quorum requirement. That means 30% of your members have to actually show up either in person or by proxy at that meeting. And out of those, at least 50% plus one individual lot need to vote in favor of whatever you're trying to accomplish. Members have the right to speak for up to 3 minutes at every meeting of the board, every meeting of the members on each agenda item. So you want to minimize how many agenda items you have. What you can also do, and I strongly recommend, is have a written policy that governs how and when members are allowed to speak at meetings. Okay, you can adopt that policy that restricts the frequency. In other words, can you talk 10 times during a meeting or only once? The duration, in other words, how long can you speak? Or the time. In other words, at which point on the agenda item are the members allowed to say their piece? At least up to 3 minutes for each one of these for member statements. So I hear a lot of associations, the board says, well, we don't have any problems, so we don't need those types of policies in place. We're not going to waste the hour or two that the attorney's fees would be to get it in place and get it enacted. I promise you that the second you have one person who attends your meetings and won't shut up, you're going to really wish you had this policy in place. So as soon as you've got that problem child, you're going to regret not doing this now. I strongly suggest that if you don't have this type of policy in place, you reach out to your attorney. If you don't have an attorney, you should, and you're welcome to reach out to me directly so that our firm can work with your community. But you want to make sure that you've got policies like this in place. That's one. I also recommend that every community have one in place regarding records inspection requests, which we'll get into later. The frequency, how often and how those are going to go within your community, collection protocols as to when you're going to turn accounts over for collection, when you're going to send the initial notices, etc., and then covenant enforcement. What are we going to do if someone doesn't comply with the covenants? Do we send 1, 2, or 3 letters, or does it go straight to counsel? Those are the types of things that I think every community should have a written policy governing how those things are going to be handled. And then you follow that policy so that the board doesn't have to think about whether or not it's going to pursue one or more violations. That's a great way to keep the board's credibility, is to make sure you have policies in place and you follow them to a T. Okay, back to meetings. The members are allowed to record every meeting. They can record it via audio on their phone or a tape recorder or whatever, a digital recorder, or videotape it. Okay, that doesn't automatically mean that members are automatically entitled to attend via phone or via Zoom. It means that they can record or tape it. Okay, closed meetings with counsel to discuss potential or ongoing litigation are not open to the members, unlike every other meeting. Also, if you're going to be discussing employee matters, and that doesn't mean whether to hire a manager or shift the particular CAM that's working with your community within the management firm, unless you're hiring or employing directly that individual, that doesn't count. But if you are talking about employee matters, you can close that meeting to the members. Now, the salaries, all of the other things that go into your official records are still going to be open to the members. They just don't get to attend the meeting. Voting by proxy, you have 2 different types. A general proxy allows a proxy holder to vote however they want on any matter that can be undertaken at a specific member meeting. A limited proxy basically says you're allowed to vote, but you have to vote in this way. Okay, it's something you can submit directly to the association saying, yep, please vote my way. General and limited proxies can be used to establish a quorum. The proxy is only effective whether it's limited or general for the specific meeting for which it was intended, and any lawfully adjourned meetings thereof up to 90 days after the date of that first meeting. So in other words, we hold a meeting to try and amend the governing documents. We have proxy forms that have been filled out by 50 of our members. That's great. They've all approved it. They don't have to show up in person. Fantastic. But they're the only ones that showed up, and that doesn't reach our quorum requirement. Well, okay, let's try this again 60 days later. 60 days later, we have the same problem. We need to try 60 days later. Well, now we're 120 days after the date of the original meeting. That proxy is no longer any good. We need new proxies from all 50 of those people. That's what this means. Every proxy is revocable at any time, including during the meeting, at the pleasure of the member who executes it. Now, you can also have a written consent, which is basically just a resolution in lieu of a meeting. It can be used unless the articles of incorporation of your governing documents say that you can't use it. This is one of those, I won't call it a glitch. It's kind of an idiosyncrasy of the not-for-profit statute, but basically this is something that a lot of attorneys don't know about, but it's good for 90 days from the date the first executed written consent is received by the association. In other words, you've got 90 days to collect all of the other written consents that basically say, yep, we don't want to have a meeting. Here's my proxy. I'm going to approve this. Let's move forward. Elections are next. This one's going to take a while, so I'm going to give a little bit of an outline in advance. Follow your governing documents. Okay, moving on to the next subject. Seriously, it's that easy. Look at your bylaws. They're almost always going to say how the election meeting should be held. If they don't, amend them to say how the election meeting should be held. Then follow that. A lot of communities that are more recent are following the condo procedure of having a whole bunch of different envelopes and ballots, and we'll go through that in just a minute. But generally speaking, if you look at your governing documents and they say, here's how to hold your election meeting, that's all you got to do is follow that. Okay. Couple pointers to avoid disputes about the validity of the election result. Make sure before you eliminate any nominations at the meeting, you make sure the documents don't allow nominations from the floor. Because a lot of HOA declarations, it's not allowed in a condo, but in an HOA, the declaration may say you can be nominated at any time before the election result is announced or before the balloting is closed. That means that you can literally just write in nominations at the meeting, or you can nominate yourself from the floor during the meeting. Okay, that makes things a little more complicated because you can't really have a write-in ballot like a mail-in if you are accepting nominations from the floor, because that person wasn't given due consideration in the mail-in. Okay. The other thing to make sure that you do is formally close the balloting at some point, because otherwise you basically will be counting the ballots all night and you'll have to just keep counting. One thing that a lot of communities that we represent will do is actually establish in advance, we're going to begin collecting the ballots at this time. We're going to close the balloting at this time. If your ballot's not been counted by then, sorry, you're out. Now, I wouldn't make that a 15-minute process, but I also wouldn't make it a 5-hour process. So you might want to consult with your attorney as to what your bylaws say that you're supposed to be doing and do it the most efficient way to make sure that you get out of your election meeting without having a 5-hour meeting for, a 100-member community, which for those in the know would be pretty ridiculous. You need a quorum at the election meeting, unless the bylaws say otherwise, in order to hold the election. If you don't have an election, that means that each each director whose term was up at the last whose term was up that required the election just stays on the board. They roll over is the term that we use. So they stay for another term. The process is regulated by the bylaws. So this is basically, here's how you can vote. Nominations we discussed, so we'll move over. Notice the annual meeting needs to be given by mail or electronic transmission, not less than 14 days before the meeting. Okay, if the bylaws are silent. If the bylaws say how to provide the notice, just provide the notice that way. Okay, we're going to go very, very briefly through the condo election process because a lot of communities, like I said, more recently in probably the last 5 years, have just gone ahead and adopted the condo process. So there are a couple deadlines here, 60, 40, 35, and 14. These deadlines are for the first notice of the election is 60 days before the election meeting. 40 days before then, all of the nominees have to have their names in the hat, so to speak. They have to give written notice of their intent to be a candidate. Within 35 days before the election, the nominees need to have actually furnished any information sheets on an 8.5 by 11 that basically says, here's why I think I do a good job, or whatever other information they want to deliver, and they're entitled to a receipt once the association gets that. Not less than 14 days before the annual meeting, the association sends the written notice of the meeting, the second notice, and the agenda for the annual meeting, and needs to mail, deliver, electronically transmit all of that, along with all of the ballots, which list the candidates alphabetically by last name, as well as their information sheets. These information sheets do not get modified in any way, shape, or form before they're sent out. The fact that you don't like them is too bad. You can request that the individuals who submitted them change them before they're sent out, but you don't have the right to unilaterally change it or unilaterally decide we're not going to send this out. You send whatever that person sent to you. If that results in some kind of defamation claim later on or some other claim later on, you deal with that afterwards. But you can't just decide, I'm not going to send it. Okay, whoever gets the most votes wins. That's what a plurality of the ballots means. Whoever gets the most votes wins. If there's a vacancy on the board caused by the expiration of a term, it must be filled by an election. A vacancy on the board caused by a resignation or removal is filled by an appointment or another election. Why would you want to go through all of this again when you just did it at the previous annual meeting or around the annual meeting? Appoint. If there's if there's someone willing to serve that you can locate and you're happy with them serving with you on the board, just appoint them at a board meeting. That's it. Don't hold another election meeting. If the number of vacancies equals or exceeds the number of candidates, you don't need an election. In other words, why would we hold an election when we've got 5 vacant seats and 5 people that want to be on the board? They're on the board. Now, if you have the ability to nominate from the floor, you may still need to have that election anyway. Keep the official records from the election for 7 years. Any challenge to the election process needs to be commenced, meaning filed, within 60 days after the results are announced. So something I've heard that's dead wrong, by the way, we talked about how if you don't have enough people that are interested, you don't have an election meeting most of the time. I've heard people say they didn't have an election for the last 3 years, so anything they did during that time is invalid, and I'm going to sue the association, the board, the management company, and all the attorneys that gave them that bad advice that said that was okay. No, you're wrong. You don't need an election unless there are more candidates than vacancies. Okay, so just keep that in mind. Let's see, I think that's it for this one. A candidate is an eligible person, which is almost everyone that is a member of the community who's timely submitted the written notice their intent to become a candidate. That could be, again, at the meeting if you're allowed to nominate from the floor. Anyone that wants to be a candidate generally needs to be eligible to be a candidate. There are only a couple things that will make you ineligible. We'll go through what they are right now. Generally, any member is eligible to serve on the board, and your governing documents may say that you don't even need to be a member, okay? But if you have been convicted of a felony and have not had your civil rights restored in the last for at least 5 years as of the date you seek election. Now, what civil rights being restored is you were released from prison at least 5 years ago, okay? So John Smith killed 28 people, wants to be on your board, but he just got out of jail 3 years ago. Fortunately for you guys, you're okay. He's not going to be able to serve because of that felony. Now, if you find out about that felony conviction and that because of this individual should not have been allowed on the board, but you didn't know about it until afterwards because your HOA doesn't have a screening process, for example. Okay, no harm, no foul. He comes off, but you can appoint a new person to replace him, but anything that was voted on by John during that time that he served on the board is still fine. Okay, another reason you might not be eligible to serve on the board. Anyone with pending charges of felony theft or embezzlement involving association funds. Makes sense. We don't want people that are going to steal your money to have the ability to make this financial decisions for your community. Someone who's delinquent in payment of any fee, fine, or other monetary obligation on the day that they could last nominate themselves cannot seek election. In other words, they cannot be a candidate. Okay. And then a person serving as a board member who becomes more than 90 days delinquent in any of those monetary obligations is deemed to have abandoned their seat. In other words, they're automatically off the board without any board decision required or frankly even allowed. Okay, so 90 days delinquent while you're on the board in any monetary obligation, you're off the board and your spot gets filled by somebody else. Now, if you come off the board, you then pay everything back. The board has not appointed anyone else yet. That doesn't mean you can't be reappointed. Okay, but you need to cure that financial debt before you'll be allowed back on the board. You need to have 3 or more directors in accordance with the bylaws. The term expires pursuant to the governing documents, but usually it's the end of every year, unless you've got different terms, maybe staggered terms. Those would need to be listed in the governing documents. There are no term limits in an HOA unless they are in your governing documents. By the way, for those of you who don't know what staggered terms are, that's where your term is 2 years. Someone else's term on the board is 2 years, but it's staggered so that in year 1, that person got elected. In year 2, you're up for re-election. In year 3, that person's again up for re-election. So that there's always someone on the board that previously served so that there's some continuity. That's what a staggered term is for. Term limits are for limiting how long you can serve on the board as a whole. Co-owners, there's nothing in an HOA law that says you can't have 2 different owners of the property that are both on the board. In a condo, there is a restriction. Okay, we won't go through the excruciating process of how to go through all of the envelopes associated with the condo procedure, but you're basically having a group of volunteers that are not on the board go through all of the envelopes they got, make sure that the identifying information for the lot or whoever it is included on the outer envelopes, opening those up, pulling out the inner envelopes, making sure that there's no markings. If there are markings, our opinion is that person has just waived confidentiality of what is on their ballot. And then once you've determined that there are no multiple ballots submitted by the same person that doesn't have the right to do so, for example, because they don't own multiple lots in your community, or basically everything else is valid and as it should be, you open up the ballots and then you move the inner envelopes into a pile, and then you count the ballots and you determine who the winner was. The thing that you need to keep in mind is that all of these documents, even the envelopes, need to be kept as part of the association's records. So it's not, we open the envelopes, we toss them. The ones where, let's say you had an outer envelope that wasn't signed by an eligible voter, you had an envelope that contained 5 different ballots for someone who only owns 1 lot, etc. Those get marked disregarded and are not counted when you are going through and counting the ballots in the election process. So I said we wouldn't go through it. We went through it very briefly. I know that might have seemed like about 15 minutes. It felt like it for me, but it's a very brief explanation of how that process works. If you don't have a provision to the contrary in the bylaws, you have a president, a secretary, and a treasurer. They serve without compensation at the pleasure of the board. What that means is the officers, which is different from your directors. Let's go through the different hats that you might wear in your community before we move on with this, so you're understanding how I'm making that distinction. Okay, you're wearing probably 3 hats in your community if you're on the board. One is as a member. That's just someone who owns property in your community. So that's a member. You're a member of the community. Another is a director. These are the people that were elected by the members to serve and make decisions for the community. Okay, it's not the officers that decide anything for the community. It's the board of directors that votes on these issues that the members don't get to vote on. This is really the operation of the community, the day-to-day, that it can't wait for a member meeting and 50+% of the community to vote on something. So the directors are the ones that make motions for the board, second those motions, vote on or abstain from voting on those motions, and that's pretty much it. That's what a director does. They make decisions by voting. Officers are the ones that have specific tasks. The president is generally going to be your mouthpiece. You've got the secretary who's going to keep all the records. You've got your treasurer who's going to keep the financial information intact. And then you've got potentially a manager who's going to do most of that for you. By the way, that's why you hire a manager, so that your secretary and treasurer aren't tasked with all of that. And you've got someone who is trained to do the job rather than someone who volunteered in a position to run a business, which is what your HOA is a corporation. Okay, you want to pay someone else who is qualified, that is licensed as a community association manager, to do that job for you guys. Okay, that is why people hire management companies. I do have people that ask, well, why do people pay this money for someone else to do something I could do? Yeah, you might be able to do it. And if you're a CPA, you'd probably be a great treasurer. But if you don't have that training and licensure, you might not be a great treasurer. Just because you were a treasurer of the Key Club in high school doesn't mean you're going to do a great job here. So a lot of times that's why people hire management firms. The directors, getting back to all of this, can't vote by proxy or secret ballot at board meetings. They also can't vote by email. You can communicate as directors by email, but you can't place a formal vote via email. You need to have some other documentation, or preferably make the discussion and voting in an open board meeting. Secret ballots can be used by the directors in electing the officers, and there's nothing against changing officers midstream. In other words, if you're not happy with what your president is doing because they're acting in a way that is not in accordance with what the entire board wants, and they're taking unilateral action that wasn't authorized by the board and shouldn't be done in the board's in the board's opinion, that person can be removed from that president slot, so that they clearly no longer have the authority to just go ahead and sign contracts that the board never considered. Electronic voting, fantastic. Not something we're going to discuss in detail today so that we can save some time, but we work with plenty of, a few very qualified vendors that do a fantastic job with electronic voting. You're going to rely heavily on your attorney and your manager to make sure that this is being done right, but it makes it very easy, including through a cell phone app, for your members to vote on amendments, to vote at election meetings, etc. I strongly suggest, if you haven't considered this and you have a problem with apathy in your community, that you look into electronic voting. Again, it's something that your vendor is largely going to control compliance with the statutes, and your attorney is going to guide you as to, or your manager might guide you as to, who the best vendors to use for this purpose might be. So we'll skip electronic voting otherwise. Board of directors, we talked about the many hats that you might wear. The other thing that I mentioned earlier, but we didn't really get into, is your fiduciary duty. So let's talk about what that actually means. It means that you owe a duty to the association, the corporation, to do what's in the best interest of the association, not even if it goes against your own personal best interest. Regardless of what your interests are, you have to run the corporation like you were trying to make $1 million, even though it's not for profit. You got to do your absolute best for this corporation, what you reasonably believe to be in the community's best interest. Now, this is a very high standard. The fiduciary duty is the equivalent of treating you like a trustee of the association corporation. Okay, it's the highest duty imposed by Florida law. Now, the good news is there are a couple things that will protect your decisions as a director. One is this business judgment rule that we mentioned here. And it basically says that if you relied on guidance from a professional that was reasonably relied on, in other words, you didn't already know it to be bad advice, if you rely on it and your decision ends up being something that was wrong, but you reasonably relied on that information, you reasonably thought that what you were doing in your good faith was in the best interest of the association, even if it's bad for you, we have the highest duty imposed by law, but the lowest standard. Okay, so it's a reasonably prudent person, it's a legal term, taking actions in the good faith belief that they are in the association's best interest. If you do that, you should not be held liable for any breach of fiduciary duty. Now, keep in mind, the second most important bill, well, third, that you might ever pay is your directors and officers liability insurance. If you don't have that, frankly, I wouldn't serve on the board if I were you. And that bill that you are paying is so that any decisions that the board makes and gets sued for, you are personally covered. If someone sues you personally for those decisions being made or those actions being taken as a director or as an officer of the association. Now, I say it's your third most important bill in order: your attorney, your manager, this bill. Moving on. And yes, that's a joke, kind of. Directors cannot receive any salary or compensation from the association for what they're doing as a director, officer, or committee member. I had someone ask me the other day, well, what if I'm doing something to, clean up after a storm, and someone was going to charge us $250 to do this work, and I went ahead and took care of it. I drove out and got this thing. Well, you're probably not entitled to that same $250 for the delivery fee, but you're probably entitled to reimbursement of your actual out-of-pocket costs, your gas, if you used a full tank, or you can reasonably calculate the mileage and what that gas costs, possibly your mileage, things of that nature. But you can't just get compensated for being a director. Okay, you can be reimbursed for out-of-pocket expenses incurred on behalf of the association, subject to applicable approval procedures. In other words, you don't want your president to go out and do all this work that the association didn't need and then say, well, I'm entitled to reimbursement for this because it's an out-of-pocket cost by me. Haha. What you want to do is have the board actually approve those out-of-pocket expenses. I think we can skip most of the rest of this because it might not apply to you guys. But if you have questions about what can you be compensated for, contact your attorney, contact your manager. Unless otherwise provided, the corporate powers are exercised by the board. In other words, the members don't get to vote on every single thing that happens in your community. Most of the board does. And again, we don't want unilateral decisions being made by individual officers or individual directors. And the board is generally responsible for the maintenance and operation of the association property. So when does this board meeting actually happen? There's no sunshine law, by the way. So when someone says, well, the sunshine law says that the association has to meet in the sunshine. No, that's a government law. It has nothing to do with HOAs. There is a statutory equivalent that says that a board meeting occurs and needs to be open to the members anytime a quorum of director meets and conducts association business. Now, what is conducting association business? That question's been asked ad nauseum. There's no definition of the statutes. My indication to you is that anytime that the board is meeting, or at least 3 out of 5 directors are meeting, and you start discussing association business, whether you're actually making a decision or not probably doesn't matter, because that discussion will then need to reoccur during an open board meeting. Why bother having the discussion if you're going to have to do it over? Now, again, you can send emails back and forth and have discussions. You're going to have to start that over during the board meeting. Now, you may email back and forth to decide which contracts you're even going to consider. That's totally okay, because you're not voting to approve them. Okay. But I wouldn't have that same discussion in a face-to-face meeting or over the phone. Email is explicitly okay. Why the legislature hasn't said other discussions are okay as long as decisions aren't being made, I couldn't tell you. But that might be an indication that the intent of the legislature was for this to mean that conducting association business is discussing association business. So just be careful. If you're not holding open board meetings, you can get yourselves in trouble. Unauthorized actions that bind the association anyway. Okay, you did something, it wasn't discussed at your board meeting. Whoa, what do we do? Well, if you want to continue with it and approve it, you ratify it at the next board meeting. If it was an emergency and something that needed to be handled right away, okay, we don't use this as a day-to-day excuse and a replacement for, well, we only want to hold board meetings once a year, so we'll just go ahead and ratify everything that's been done over the last year. No, we're not going to do that. Okay. You might also have a parent authority. This is where it gets a little hairy when your president is doing whatever they want. without board authorization because they have a parent authority to act on behalf of the association. Okay, that might mean that you end up in a contract that the association's board didn't want. You can avoid that by informing vendors who the authorized contacts are. You can also potentially avoid it by requiring multiple signatures on every association contract. A lot of communities will require a signature not only of the president, but also of the secretary on any contract the association signs. That can avoid the issue of having the president just do whatever they want. And I know I'm singling out the president. That's because most of the time, no one's going to accept just a signature from the treasurer. Okay, so I'm singling that officer position out on purpose because most of the time they're going to go back to the board and say, was this authorized? If it's the treasurer or the secretary who's trying to sign, the president is generally going to be your figurehead that's authorized to do those types of figurehead tasks like signing a contract. Again, you can email, you can't vote via email. Okay, there's no such thing as a free lunch. You can't solicit, offer to accept. This is the kickback provision. Solicit, offer to accept, or accept anything of value for which consideration hasn't been provided for your own benefit or that the benefit of an immediate family member from anyone providing or proposing to provide goods or services to the association. Again, no kickbacks. If the board finds that an officer or director has violated that subsection, the board immediately removes the officer or director. As of this year, I think it kicked in July 1st. There are also civil penalties. Okay, it's not criminal yet like it is in condo world, but there are civil penalties for taking kickbacks. Okay, you can, however, accept food to be consumed at a business meeting with a value of less than $25 per individual or a service or good received in connection with trade fairs or educational programs. That's why if you go to some of the expos and other trade fairs that our firm attends, you'll see me and Jeff throwing the soft KBR squishy balls at each other and handing them out to people along with pens and pads for our firm. That's at a trade fair and an educational program. So if you were to attend this in person, exactly. Yeah, I know Jeff always wins those wars and that's fine with me. And the good news is we're smart enough to be lawyers about it. We make them squishy so that even if you hit someone right in the noggin, you're not going to leave a mark. So it's perfect. So just bottom line, don't take kickbacks. You can take the little stuff at the trade fairs, the educational programs. You can meet with me for lunch as long as the food is not more than $25 per individual. But you can't really go and accept something from someone who is proposing to do business with the association other than that. You are deemed guilty until proven innocent. If you are an officer or director charged by information or indictment, these are criminal law terms that the criminal courts will do with a felony theft or embezzlement offense involving association funds or property. That person is automatically removed from office. That vacancy is filled by the board. Usually it's going to be, like I said earlier, by just appointing someone until the end of the suspension, which is up when they get found not guilty, or acceptance of a plea of guilty or no contendere, which is a legal term. They are reinstated for the remainder of the term. Okay, so in other words, you suspend as soon as this happens automatically without question. It's not saying we agree that this person's guilty. It's saying we have a legal obligation to remove them from office. If the charges are pending, you cannot be appointed or elected to a position. That's, again, one of the things that will make you ineligible as an officer or director. Okay, board meetings, 48 hours notice posted on the property. And this can be something, when I say posted notice for a board meeting, that literally can mean you take one of those paint sticks, you shove it in the ground, you put some cardboard up, staple it to the paint stick and handwrite in black magic marker, board meeting to be held on this date at this time at this location. That's enough for posted notice. If you've got something, let's say in a clubhouse or at a pool, a bulletin board, that's the place you'll want to put it instead. If it's a board meeting that is to discuss non-emergency special assessments or amendments to rules regarding unit or parcel use, that needs 14 days notice and it needs to be mailed instead of just the posted notice. My suggestion, post it anyway. Moving on, agendas. This is a little outdated now that as of October 1st, you will need to have an agenda. So technically it's still accurate, but not for much longer. So if you're watching this after October 1st, I'm not giving you bad information. You do need an agenda beginning on that date. And this is October 1st, 2023, just to be clear. Notice of any, see, you know what? The lawyer always comes out. I apologize. Notice of any board meeting at which regular or special assessments are to be considered. Need to state that the assessments are going to be considered and provide the nature of the assessment. We discussed this earlier. And then for special meetings, if 20% of the voting interest petition the board to address any item of business, that is a special meeting of the board. Within 60 days, it needs to be held. Okay, so it's either the next board meeting or a special meeting called for the specific purpose of dealing with the issue that the members are raising. Again, we talked about member participation, same thing as we discussed before. The members can participate, can record or videotape, and they can speak. The association can and should have those written policies that we discussed earlier, and it should encompass both board and member meetings. So we won't go into detail about that because we went through it earlier, but I want you to understand it's exactly the same for board meetings and member meetings in this respect. A quorum is a majority of the board at a board meeting. If you don't have a quorum of the board, you don't have a board meeting. When you're meeting by phone or by video conference, keep in mind that that still counts towards the quorum as long as you're participating as a director and on that meeting. Speaker needs to be used so that the conversation can actually be heard by the board or committee members that are attending in person and by any unit owners or lot owners that are present at that meeting. So keep in mind, yes, you can attend by phone, you can attend by Zoom, but everyone else still needs to be able to observe just like you were in the room because they have the right to be there. They have the right to observe and participate as members in your board meeting. And you can also vote at board meetings and appear by that video conference or phone, as long as everyone can hear you. What do a golem and a board workshop have in common? They don't exist. Stop making things up. Okay, a workshop is used as a tool to get around noticing board and committee meetings. If you have a majority of the board that is meeting to discuss association business, you have a board meeting and it needs to be noticed. It's not a workshop that you can close to everyone else. Same thing with committee meetings. They need to be open. If a final decision will be made regarding expenditure of association funds, or if it's an ARC or ARB meeting and you're going to approve or disapprove architectural decisions, these all need to be open, noticed, and open to the members. If the association's entering a contract with one of its directors or any corporation, this is conflicts of interest. I'm going to say you need to be very clear and disclose that this conflict exists. I'm going to be brief because we have an entire class specifically pertaining to conflicts of interest that I recommend everyone watch, because we are now 1 hour and 40 minutes and 63 slides into 153, and there's not a lot of time to get through the entire rest of this. But seriously, watch this conflicts of interest webinar that we've done several times over the last year. It's on our website at kbrlegal.com under the resources tab. It goes into a lot more detail, but for now, all I'll say is 2/3 of the directors present at the meeting where this contract is being contemplated need to approve it. So it's a super majority. The individual who is trying to push this contract through is, if they're a director or someone that's related to the director, that director can push that and participate in the entire discussion until the board is discussing and voting. At that point, that person steps out of the room and they need to abstain from the voting so that there is no undue interference with the board's decision-making ability. Okay, them being in the room, is deemed to potentially interfere with the rest of the board being potentially bulldozed into voting in favor of the person that they're working with. Relative here, by the way, for purposes of determining whether you need to disclose this type of issue, it means the 3rd degree of consanguinity, stated in plain English. That is a legal term that means your spouse, child, parent, sibling, grandchild, uncle, aunt, or grandparent. Okay, so those are the people. If you have a relationship with someone with a deep interest in this company, you need to disclose that relationship in advance of trying to promote this contract. if the members decide to cancel the contract by pointing out the conflict that they've found out about at the next the next member meeting, and vote in favor of canceling the contract, a majority vote of the entire of the members present at that meeting can cancel the contract, and the contractor, who presumably knew about the conflict, is only entitled to what they've incurred expenditure-wise and what they are entitled to under the contract through that date. There's no liquidated damages. There's no, well, the contract was supposed to last another 5 years. Nope, you cut it off. Now, if at that next member meeting, other than the election, the members don't actually vote to cancel that contract, they lose the right to do it indefinitely until that contract expires. So I know that was a lot, but the webinar is actually over an hour talking about just this one subject. So I wanted to make sure that everyone knows to look out for that conflicts of interest webinar. How to get off the board: you resign, you get recalled, which means removed, whether you did something wrong or not, but a majority of the members want someone else in there instead of you. You're delinquent in the payment of any monetary obligation due to the association for more than 90 days. Criminal charges involving theft or embezzlement of association funds or property, failure to satisfy this certification requirement that you're complying with today, which is a suspension, not a removal, by the way, until you get that certificate in the association records. Receipt of gifts exceeding that $25, or you die. That's the other way to get off the board. That's honestly, it's one of the hardest ways to get off the board. But it's another way, because you can't really serve if you're not living. Moving on, budgets, reserves, and financial reporting. We're going to try and breeze through this. I'm going to explain budgets. Here's what they are. They are the best guess of the board as to what it's going to actually cost to properly maintain and operate your community in the next year. You need to prepare one, and it needs to include your estimated revenues, what you're going to bring in, operating costs, what you're actually going to spend this year. And when I say actually going to spend, I use that word intentionally, not what it's going to be easy to get the members to pay. You need, under your fiduciary duty as a director, to include every penny that you think it's going to cost to fully and properly maintain your community in the next year. If you've got reserves established, those also need to be included. Okay, if your association's actually following your budget nearly exactly, you're either the luckiest community in Florida because you ended up with exactly what you thought you would spend and exactly what you thought you'd bring in with no delinquencies or exactly the delinquencies you anticipated, or you're doing it really wrong. You're limiting your expenses to what you originally estimated so that you look better next year. The problem with that is that when you're limiting those expenses, what that means is you're not fully and properly maintaining and operating your community, which is what your fiduciary duty requires. So you need to make sure that whatever is needed to properly maintain and operate your community in the next year is what's included. If you're not doing that, one, you're not doing what you're supposed to do, and two, the maintenance that you're not performing this year will inevitably cost even more to do next year when you haven't maintained that component at all. So we've dealt with situations, and I've personally dealt with situations where jobs that would have cost $100,000 in year one, well, the board didn't want to include that in the budget, so they pushed it off another 3 years. Found out in year three that it would actually cost an extra $500,000 to do the work, and you end up with a snowball, okay? Because it costs more, inflation goes up. Without getting the work done, you end up spending $1 million or more for that $100,000 project that you could have spent another $100,000 on 5 years from now. So put in there what you actually think it's going to cost to properly maintain. Okay, you have no right as a director to artificially water down your budget just to placate your membership and get elected again the following year. Because as soon as they find out that you haven't been doing the maintenance, guess what's going to happen? You're not going to get reelected like you wanted. Okay, the owners have a right to know what you should be spending. They also have the right, which we'll get into in a minute, to present an alternative budget if they don't like it. But you comply with your fiduciary responsibility to put out a proper budget. And if the members don't think they can afford it or don't like the budget, let them make the unilateral decision. Okay, well, we're going to present this alternative budget and go through the entire process of getting this new budget passed. Because the alternative is you end up with enormous special assessments that your members, many of whom are probably on a fixed income, can't afford to pay and end up getting foreclosed. So you end up with a parcel of property that you can't do anything with other than maybe rent or sell while you wait for a lender to foreclose, by the way. It's just, yes, that can be beneficial. I've got communities that are renting out properties after foreclosing that have been renting for the last 3 years before the lender forecloses, but they're constantly in fear that that spigot is going to get shut off, so to speak. So you don't want to make that the thing that you're relying on to properly operate your budget. So again, just do what you really think is going to be needed and put that in the budget. So there are some budget items that need to be included. Your manager, if you have one, is generally going to assist you with your budget. If not, I mean, this is pretty clear. You'll have the slides later, so I won't go through it in detail. Once the board has prepared it, that budget is typically adopted by the board, meaning the members don't initially get to vote. If the documents don't say how to adopt the budget gets adopted by the board through a regular board meeting notice. An assessment can't be levied at that board meeting, though, unless the notice of the meeting includes a statement that assessments are going to be considered in the nature of the assessments. So yes, technically you only need 48 hours notice. Some people will do 14 days notice because of that additional notice requirement for assessments. Once the budget's been adopted, the association must provide each owner with a copy or a notice that a written copy can be made available upon request at no charge, which is different from other records that the owners might be inspecting. You don't get to charge for copies of that. Okay, reserves. We're not going to go through in detail because unless you have them, this is completely irrelevant to you. The only way that these reserves, which is basically money that you're putting away for a specific asset of the association to be maintained, repaired, replaced in the future, not that once a year expense of maintenance. We're not talking about pool maintenance. We're talking about replacing the pool because it's 30 years old and it's cracked and needs to be completely replaced. Okay, these are the types of things that you might reserve for. If you don't have them created by the developer, by the membership via a board vote, or in your governing documents, you don't have reserves and you don't need to worry about any of this. I'm not saying it's a bad idea to establish them, but that means that that's a fund that is limited to being used for those reserve assets. So you may have money that you're putting away to make sure you have the money when that pool fails and you need to completely replace it, which, that could be a $300,000 expense at that point for all I know. But you're putting that money away, and unless you've got it in a pool with other reserve items, you can't use that money for anything else without a member vote. So some communities will say, well, when that is expected to fail, we'll put the money aside and have unofficial reserves. If you've got any major expenses that are going to be required more than once every 50 years, I do suggest that you establish some of these reserves. But the good news, again, if they're not established, you don't need to worry about them. If they are established, reach out to your manager or your counsel. But this allows us to kind of skip through some of this. Your financial reports, which will go through what's required. Within 90 days after the end of the fiscal year, the association has to prepare and complete or hire usually a CPA or some other kind of accountant to prepare and complete a financial report for the preceding fiscal year. Within 21 days after that's completed, but no later than 120 days after the end of the fiscal year, and your fiscal year may be December 31st or maybe something else, look in your bylaws. That'll usually determine what the fiscal year is. The association needs to provide each member with a copy of that financial report, or again, written notice that it's available upon request at no charge, just like your budget. Okay, we get into now, and I don't know if any of you know this that are on the call. Biggie Smalls was actually a CPA. So the way that this works is he actually postulated that the more money you have, the more problems you have. And that's exactly what happens in an HOA context. So I won't go through the specific reporting requirements, but basically the more money you have within these specific components of dollar figures that you're bringing in throughout the course of the year, regardless of what you spend, this is how much is your assessment every year. And as you get into a higher dollar figure that you're bringing in, you're going to need to have a higher reporting level. So you go from the bare minimum of basically you have $150,000 or less you have a spreadsheet and that's about it. But once you get into $500,000 or more, you actually need a CPA that will audit every record of the association. So we're not going to go through in detail as to what these are. Your manager or your attorney is going to help you through this if you're not sure what you need to do. These are just some things to think about if you're not already aware how to do some of these things, but every director really should understand how these things work. If you don't, please check our website for resources. There are older articles available on every single one of these issues. Anything you don't have might also be in one of our webinars. And if you still don't know, you're welcome to reach out to me personally and I'll walk you through it for a couple minutes, either over the phone or in a quick email. Whether you're a client or not, and whether you ever intend to be a client of our firm or not, I'm happy to provide that kind of education. Meeting minutes should not be a verbatim copy of what was discussed at the meeting, period. I see all of the time 5 paragraphs on one vote. The bottom line is, here's the motion that was made. Here's who seconded it. Here's how each member of the board voted. That's your meeting minutes. Oh, and by the way, also, here's how it ended up. Okay, here was the result of the vote. It either passed or it didn't. That's it. Shouldn't be verbatim records. Minutes of all meetings of the members and of the board should be maintained in written form or in another form that can be converted to writing within a reasonable time. In other words, I don't want to see 6 months after a meeting that you've still got no minutes in your official records. That's just, it's not illegal, it's not improper, but it's not good. And anyone that is trying to figure out what happened at that meeting is going to say, can I have a copy of the minutes? And they're going to request to inspect those records. And if they don't exist, it's going to look like you never had the meeting, and that's just not good. Voter abstention by each director and each member should be recorded. The other thing that I want to be clear on, and I think I highlighted it but didn't clarify earlier, abstaining from voting doesn't mean I don't like what we're talking about, so I'm not going to take a position. If you are a director, you are obligated to vote on everything. The only reason to abstain from voting is I wasn't at the meeting, so I wasn't able to vote, or I have a conflict and I'm not allowed to vote. That is the only real basis for abstaining to vote at a board meeting if you are a director. Access to parcels, the governing documents may provide, might not, the right to access an individual parcel for emergencies or undertake maintenance obligations. That's called self-help. It's something that's become more important with case law that came out last year that basically says you should be doing this before you seek an injunction against the owner. You should be trying to cure this yourself if you have the right, not the obligation. It doesn't have to be the association shall do X. It's the association has the ability to cure the violation itself that invokes the, well, you know what, if you have that right, you may not be able to get an injunction. So be careful, make sure that you're not ignoring the fact that you have a self-help right, because I've seen a lot of attorneys even in recent months after that case came out a year ago that are still saying that they're refusing to even attempt self-help and they're still going forward with injunctions. And you're starting to see people that are making arguments that a judge might side with them, saying you can't get an injunction if you have a self-help remedy that you didn't try to use. And that is a very detailed issue that could be the subject of another hour-long discussion, which, Jeff, I guess mark that down as a potential topic to run by our partners and figure out whether they want to do a class on it. Next one, Marketable Record Title Act. So this is basically a law that says, hey, it takes way too long to go through all the public records to determine whether a covenant should still be in place. Covenant is basically a restriction on how you can use property. Okay, so covenants actually get extinguished and become ineffective, in other words, unenforceable, 30 years after the initial recording of the declaration. Now, that's a very simplified way of putting it. In reality, it's 30 years after the date of a root of title is the legal term, which is usually going to be the transfer of title from the developer to the first owner of each lot. You can avoid this in several ways. Okay, there are a lot of exceptions to the general rule. But what I want to be clear on is you want to avoid this. You don't want your covenants to be unenforceable. Because what happens when this time frame expires, however you identify what that time frame is, it's 30 years from a specific date that your attorney should be working with you to avoid allowing this expiration. If it expires, your covenants are no longer enforceable. You cannot enforce, you'll have the owner with the pink and polka dot house and not be able to do anything about it. You'll have owners that don't pay assessments, but you can't enforce the unpaid assessments because they don't have a covenant requiring them to pay the assessments anymore. So these are all things that you want to make sure under the Marketable Record Title Act that you are preserving your documents before they expire. Okay. If they don't expire, if they do expire, there are still things you can do, but it requires a member vote. As of, I think, 2018, there's an easy way to preserve the governing documents that only requires a board vote, which makes it a lot easier. Okay. Revitalization is that process of trying to get the documents back in place afterwards, which is much more expensive and much more complicated. Okay. Preservation is basically just recording something that says the board has voted and wants all of this to stay in place, and your attorney can prepare that for you. The revitalization requires a lot more. It includes government interference is the way I'll put it, because the government entity called the DEO gets to decide whether your revitalization process was sufficient and complete, etc. It's just a mess that you want to avoid. At the first board meeting, excluding the organizational meeting, meaning the one right after the election that follows the annual meeting, in other words, the next one, the board must consider whether to preserve the covenants. So this is something you should know every single year that you are contemplating, hey, are we coming up on this date? At least a year in advance of that date, you'll want, and probably up to 5 years in advance, you'll want to start thinking about having your attorney draft the preservation documents, just to make sure that you have no risk of being found to have had this expire. You need to let process servers who are trying to serve copies of a lawsuit or documents in a lawsuit, subpoenas and things of that nature, you have to let them into the community to serve process. It's not something that's optional. Even if you have a guard gate, that guard gate needs to be notified that they need to let in any licensed process server. You can have rules and regulations. We talked about this. We also talked about the 14 days notice to the members that needs to be mailed and posted in a conspicuous place in the community. Now, there is a question that arises if you are talking about rules and regulations governing amenity use. Does that govern use of a unit or parcel that requires 14 days notice? My response is probably not, but give the 14 days notice anyway, because how hard is that to do? The board's still going to be the one that gets to vote on this. You're just giving an extra, 12 days notice before you hold the meeting and adopt the rules. It's not that difficult. I would suggest you just go ahead and do it. Some governing documents may require approval by the membership of these things before they become effective. I haven't seen any, but I know that others within our firm have. Just have your attorney look out for not just preparing those rules and having the board approve them, but actually checking to make sure in the bylaws or in the declaration that the members don't get to vote on those rules and regulations. And then a copy of the rule and regulation or amendment to the rules and regs should be provided to each owner in advance of the effective date to ensure that the owners know about the new rule or at least told about it by the time it becomes effective, because it generally becomes effective only on delivery to the owners. You might also consider having it recorded in the county record so that not only your current owners, but everyone that takes ownership in the community after, or resides in the community, or frankly even visits the community or thinks about the community, is deemed to be, in other words, legally obligated to be aware of what's in those rules and regulations. And that only happens if they're recorded in the county public records. Material alterations, generally speaking, we're talking about changing visibly the form, shape, elements, or specs of a building from its original design, plan, condition, so that you can basically tell that a change has been made. These may require member approval. Usually they won't, but they might. And in the HOA context, it's usually not required that the members approve, but the governing documents may require membership approval on certain improvements, or where you tend to see it a little more in an HOA context is you require a membership approval on certain dollar figure expenditures. In other words, if the association is going to spend more than 10 grand on any one improvement, the members get to vote on whether or not that's acceptable. Well, how many things can you do that are going to change the appearance of the community other than maybe new landscaping and things of that nature for less than that $10,000 figure? So you might be obligated. Now, there is an exception to that rule, even if in the governing documents, the members do have the ability to approve this in general. If the change that's being made is necessary to maintain or protect your common elements and the association property, the members don't get a say. The board gets to just go ahead and do it. Now, the Tiffany Plaza case is essentially a case where a rock revetment wall, if you don't know what that is, because I didn't either until I read the case, it's basically the wall that you see at the edge of a waterway that is made of either stone, cement, or some other kind of rock that breaks the water from running over onto the grass, onto the walkways, onto the roads, etc. So that was something that was deemed to be intended to protect the association's common areas, that grass, the walkways, the drives, etc., from damage from the waterway. So it was a protective measure that didn't require approval from the members, even though it was a material alteration that changed the appearance of that edge of the waterway. So when you're making a change that's for the protection of the common areas or the other association property, that's generally not something that's going to require member approval. Run it by your attorney if you're not even remotely uncertain, because you don't want to make the change and then have an owner sue the association to have that change removed. In other words, to undo it and then have to get the vote and redo it and spend all that money. The association can establish architectural standards if the declaration allows for that. In order for those architectural standards to be enforceable, however, the association needs to ensure that they are clear to actually say, well, here's what, it needs to be, and this is the statutory language. The authority is specifically stated or reasonably inferred as to the location, size, type, or appearance of any of these things that the association gets to govern. In other words, if your governing documents say the association gets to decide whether fences are allowed, but doesn't say that fences need to be made of certain material, a certain height, certain color, etc., then you can't likely govern any of those issues. You just get to say yay or nay as to whether a fence gets installed. And it may not be sufficient to have that in the governing documents to say you can't install the fence. Okay, so those architectural standards, generally speaking, are going to be something that the association, the board gets to decide on. Again, that is a 14-day notice before any amendments to those architectural standards happen, but make sure that they're at least clear enough that an owner can tell exactly what is going to be allowed and what is not. Because if not, then it's entirely feasible that a judge is going to find you didn't meet the statutory requirements to be able to enforce those architectural standards. Another few things that we don't mention here, but the board should be aware of, especially the Architectural Review Committee, if you have one, should be aware of. There's the OTAR, the over-the-air device rule. I think that's what it stands for, but it's over-the-air devices. Basically, you can limit the installation, but can't prohibit. You can limit the location, but not whether or not someone gets to install certain things. So there's the OTAR rule, the statutory energy devices rule. You can limit their location, but you can't prohibit solar panels, clotheslines, satellite dishes, things of that nature. And you can only protect against certain locations where these things will be visible if it won't interfere with the utility. In other words, if you're requiring people to put these solar devices in a place where there's no sun, then that's violating the statute. If you're telling someone you need to put your satellite dish at ground level where it's not visible and it's basically under your roof canopy, but that means that there's no signal coming to the satellite dish, that's not something that's going to be compliant with the statute. So just be careful of that. We're going to breeze through the emergency powers, but just understand they were clarified in 2021 to basically say that instead of just an existing damage, it arises, these emergency powers that associations can have arise as soon as there is a declared state of emergency. They last until the state of emergency is declared complete and removed. And it is now something as of 2021 because of COVID, where you also have these emergency powers, not only where damage has occurred, but where damage or injury is anticipated in connection with that state of emergency. So again, where we were talking about COVID, you could have emergency powers to not have meetings in a public setting for a certain amount of time. Now that that state of emergency has been declared complete and over, you might not have that right anymore, even though there's plenty of people that are still doing it under different laws. Okay, so moving on from emergency powers to try and get through, because we're on slide 90 out of 153. Board member emergency kit. In addition to what's mentioned here, the other thing that I will add is my recommendation: have a bunch of emergency battery backups for cell phones and laptops and things of that nature, because if you have those batteries, I think I have one here. I have a beastly one that is intended for a laptop. This thing is like 30 pounds, which is why I don't really carry it with me everywhere. But if I'm going to be in the courthouse or somewhere else all day, and I know I might lose power in my cell, I might lose power in my laptop, I make sure to bring it with me. You might want to have several of those owned by the association and available to the directors in the event of an emergency that are always kept fully charged, so that you are able to communicate. Even if those walkie-talkies are there, you don't know how effective they'll be. You don't know what their range will be once they are, plugged in and charged. So if there's cell service, you might want to be able to use it. There have been changes also to amendments that you put in place regarding leases. It used to be that the association could only restrict leases with new amendments against people that, or only enforce new leasing amendments regarding people that actually voted in favor of the amendment or bought in after it was already enacted. Now, as of 2021, those will also apply across the board within the community to anyone, any amendment that talks about rental agreements for a term of less than 6 months or more than 3 times in a calendar year. If you have one of those two terms, it applies across the board. They don't apply to associations with 15 or fewer owners. That's going to be probably across the board, regardless of what the restriction is. Change of ownership is redefined for purposes of these leasing amendments. Bottom line, if you've amended for with respect to leasing, reach out to your attorney and make sure that that change of ownership actually was something that is going to make this person subject to the amendment. Also, when it comes to any amendments that you're attempting, if you don't think you can actually get the vote, you might start as a practical suggestion by amending the quorum and amendment provisions first, and then working on the substantive amendments, which was your original goal, once it's easier to actually get other amendments through. Again, electronic voting is something that will also help a lot. If you are using a manager for your community, if it's done for remuneration, meaning they're being paid, and the association has 50 units or more, or I'm sorry, more than 50 units or an annual budget in excess of $100,000, that individual needs to be licensed. Okay, someone that just does clerical functions under the supervision of a licensed manager does not need to be licensed, but that individual manager, even if it's someone that you are employing, needs to be licensed if these conditions are met in your community. Proposals to amend the governing documents are probably going to be prepared by your attorney, so we won't go through them in depth, but when you're talking about an amendment, changes get underlined, deletions get stricken, and if you are making such substantial changes that it would make no sense to the person that's trying to read these documents to try and read through them based on these underlines and strike throughs, you'll just put substantial rewording, see governing documents for current text, and the proposed amendment will contain what's actually going to go into the amended version rather than this strike through and underline. Okay, we talk about disputes. Mediation is a beautiful thing. There's a reason I got certified. It works. I've dealt with cases where $100,000 debt suddenly was reduced that an owner was seeking $100,000 in settlement. We ended up settling for 20. Everyone was very happy walking away from it. You never know what the other side's really looking for until you sit down and try and resolve this stuff. So if you're sitting here saying, well, if they're not going to do what we're asking for, then we'll take them to court. Okay, great. But before you do that, if it's a dispute under the statute that we're talking about, you got to offer free suit mediation. So this is one place that gives you the opportunity to try and get some of these issues resolved before you go to the extent of filing a lawsuit. So these disputes involve covenant violations, changes to the parcel, amendments to the governing documents, meetings of the board and committees appointed by the board, membership meetings other than election meetings, which are dealt with separately, access to official records, and covenant enforcement in general. Okay, we've got a list here of things that can go straight to court, meaning, yeah, okay, I've told you that some of these things require pre-suit mediation. You don't have to send it, and frankly, sending that notice would be invalid under the statute, but might get you to mediation anyway, which is why some communities will send it other than, pardon me, collection of these assessments, fines, or other financial obligations. But these things on the bottom list generally have nothing to do with what we're talking about here, which is to force the parties into mediation by statute. The division has jurisdiction over HOA election and recall disputes. That's why I said we're not talking about mediation there. We're not talking about going right to court. We're talking about filing a petition for arbitration with the division. The pre-suit mediation procedure is pretty simple. You send a letter, it's good for 20 days, and it basically says, here's what we think you're doing wrong, other side. If you don't agree to mediate in the statutory manner, which is by sending the agreement to mediate form that's attached to my letter, sending it back to me via certified mail to the address that I tell you to send it to, then you haven't complied with the mediation requirement, and we're able to move forward and file our lawsuit. If the owner does agree to mediate in the statutorily compliant form, or frankly, even if they don't comply in the right form, I usually will write back and basically say, without waiving our right to argue that you didn't comply with the statutory requirements, we'll go ahead and mediate. Now, the reason that I do that is because anyone that doesn't comply with those statutory requirements, even if they win a lawsuit that is filed after the mediation offer is sent, they don't get to recover their attorney's fees and costs, which they would otherwise be entitled to do if they win the lawsuit. So if you get one of these, I always suggest responding to it unless you're adamant that it is not a dispute that is subject to pre-suit mediation. And even then, again, you might want to respond and just try and get this thing resolved anyway before a lawsuit gets filed. If the owner doesn't respond, or if, and when I say the owner, this could be something that gets sent by the owner to the association as well. But if the receiving party doesn't respond, then that means that mediation is not required. If mediation is required and it's held but doesn't result in a settlement, that's called an impasse. If no settlement is reached at mediation or it's not held, you can file your lawsuit. That's it. Now, you might have non-binding arbitration. That's generally not going to happen in an HOA context, but it might happen with respect to your election disputes. Bottom line, you're going to want to rely heavily on your attorney anytime you're in arbitration, so we won't waste a lot of time with that now. Okay, the general enforcement process that I mentioned earlier, it's pretty straightforward. You send your demand, they don't do it. You send another one, they don't do it. You send it over to us or your counsel. The attorney sends a nice nasty gram that says, hey, you were supposed to do X, Y, Z, you haven't done it. And if you don't do it within a certain amount of time, we're going to move forward. Then you send your offer for pre-suit mediation and or your self-help demand letter. That self-help can generally be demanded at any time, but a lot of communities I have recently seen sending it out along with the offer for pre-suit mediation. And you then, if both of those expire, there's no response, there's no curative action, you either proceed with self-help or you file your lawsuit, or a combination of both. Most of those self-help provisions, by the way, will make that cost that the association is incurring, they'll make it an assessment against the lot, meaning you're not just out of pocket that money, it's just another avenue for you to go after and potentially foreclose because the owner didn't do what they were supposed to do on their lot. Now, the other thing I'll mention is this $100,000 rule that's in the slide that we have here. If a lawsuit that's filed by the association involves more than $100,000 in damages that you're seeking, the association must obtain the affirmative approval of a majority of the voting interests at a meeting of the membership at which a quorum has been attained. Now, so what? You file your lawsuit, you didn't do this, you know what's going to happen? The judge is going to kick it back to you, put the case on hold until you do this. And then once you've done it and got the required approval, you report back to the judge, have the meeting, the minutes of the meeting, recording the vote and saying, yep, this was approved now. And the judge says, okay, let's move this forward. It is intended as a shield to the owners as a whole and not something that a contractor can use, not something that an individual member should be able to use as a shield against being sued by the association for wrongdoing. The other thing, attorneys' fees and costs are generally awarded only if they're authorized by a statute or contract, but you're almost never going to be made fully whole. So chances are, because the judge gets to decide what's a reasonable fee, and an arbitrator will always say a reasonable fee is $100 an hour less than every attorney in Florida charges. Keep in mind, chances are you're not going to recover everything every time that you file a lawsuit. So keep that in the back of your mind when you decide whether or not you want to pursue some of these matters. Treat others how you want to be treated. I know that's the golden rule. I know you've heard it 8 million times, but it really applies here. You know, you're talking about your neighbors, you're talking about your community, and you don't want it to be a place where everyone's afraid, but you do want it to be a place where everyone knows, I'll put it mildly, mess around, you'll find out. The board has some credibility. The board is going to go after people who ignore what they're obligated to do. We'll talk about official records briefly. Basically, there is a laundry list of items in the statute that we won't explain, and here's why. Number 13 is all other written records of the association not specifically listed, which are related to the operation of the association. In other words, anything that qualifies as a written record of the association gets shoved into that box of association records, whether it is a packet of gum that you wrote on the back, or the wrapper that you wrote on the back. Oh, reminder, contact this contractor regarding this contract. Technically, that could be deemed an official record of the association. Okay, association needs to maintain those official records for 7 years, except that board certifications for 5 years, or until the person comes off the board if that's later. And bids that are accepted by the association need to be kept for 1 year. Okay, again, this is the catch-all, number 13 here. The other thing that I want to make sure the association's aware of, okay, effective in 2021, ballot sheets and all other election records are kept for at least 1 year after the date of the election, vote, or meeting. Even though they are association records, information you get in a gated community with respect to guests' visits is added to the lists of official records that are not subject to member inspection. So again, we talked about, oh, well, everything is basically an association record if it's a written record. Yeah, but there are some records that aren't accessible to members, and I will go through what those are. So you've got your catch-all, and then you've got your yeah, but, which is this. Okay, attorney-client or work product privilege information is not subject to disclosure. Okay, if your attorney prepared it or asked you to prepare it, it's not something that you need to send to your members or allow them to inspect when they come in to inspect your records. Information regarding leases, sales, or transfers of ownership, medical records that you might get, let's say in a personal injury case, or with respect to a reasonable accommodation or a reasonable modification request, personnel records of the association, association passwords and software that allow for manipulation of data. In other words, you're going to produce a PDF printout of your QuickBooks data, not access to the system that it's on. Certain personal information of the owners, which they can then unilaterally choose whether it's okay to disclose. Consents that are provided for any purpose. And then good news for once, if you inadvertently disclose any of this information that's not technically an official record that the members are entitled to receive, no harm, no foul. Okay, we talk about attorney-client privilege. Keep in mind, this is a privilege of the board of directors as a whole. It is not the privilege of the president to waive. It is not the privilege of the attorney to waive. It's not the privilege of the manager or the law firm to waive. The board needs to vote whether to waive this privilege or not. And when I say waive, I mean to disclose any of those attorney thoughts and advice, whether to have a meeting closed or open. That is a board decision, not a decision of any of those other individuals, or frankly, any individual. Okay, so any correspondence, letters, emails from the association's lawyer, don't waive the privilege by handing them over to someone that is not a director, not a manager, or not a member of the association's law firm. Okay, the records need to be maintained within 40 miles of the community or in the county where the community is located, and produced within 10 business days. Again, that 10 business day deadline. They need to be produced to the person that requested them in writing, not just a call saying, hey, can I have this? It needs to be in writing. Now, that can be an email, but it still needs to be in writing. And you need to produce that within 10 business days. Okay, that right to inspect includes the right to make copies, and the reasonable expense of the members. The reasonable expense of making those copies can be passed along to the members. Okay, you could also provide it via email free of charge, so that the association doesn't have to go through all this rigmarole of setting up an inspection. Now, what the association actually needs to do when you get this request within the 10 business days is basically either get the records that have been requested over to the owner, but keep in mind, they don't have to request specific records. They can say, I want to hold a records inspection. They want to just take a look at, let's say you've got 50 boxes of association records. They want to inspect them. They're entitled to do that. Okay. So if they've specified what they want, go ahead and send it over and you're done. If they haven't, then keep in mind, you may be obligated to do more than what you want to do by offering a time, date, and location within those 45 miles or within the county, like we said earlier, when they can come to an office, wherever that might be located, that's within that physical area, and physically inspect the records. Now, those records can be maintained on a computer. They can be maintained however you want. They can be on your website behind login credentials, and your entire response to every records inspection request is, here, go log in on our website and you can access literally every record of the association. That is an accurate response, unless they don't have access to a computer, they don't know how to use a computer. You basically have to make sure that they are actually given access. So even if you've got the ability to provide that on the internet, you might have to have a computer available that has a printing capability and in your offices, etc. Now, if you don't provide this, there is a rebuttable presumption that arises where if you didn't provide these records within 10 business days after receiving that written request, that was intentional. Okay, you can show someone, well, it wasn't intentional. Our website was down for a week and a half and we only have access through the website. Okay, but it then becomes the association's burden to prove that that actually happened. The law presumes that the association intentionally failed to produce those records if you don't produce them for inspection within 10 business days. There are penalties associated with that. There's a $50 a day penalty beginning on business day 11 up to $500. I call it the $500 gift. It's one you never want to give an owner, okay? Because this is actually fairly easy to comply with. You produce the records for inspection within 10 business days, period. Now, keep in mind, when I say $500, that doesn't include the attorney's fees and costs that owner will also be entitled to. And that also includes sending the offer for pre-suit mediation, going to mediation, trying to get this settled. So settle with that owner as soon as possible if this comes up. I said you can establish rules regarding frequency, time, location, and notice and manner of records, inspections, and copying. So have that policy. Now, we're running short on time, so there's a couple sections that I won't get to at all, but I'm going to try and be as brief as possible with the rest of what we've got here. Now, the request needs to be submitted by certified mail, return receipt requested. If it's not, that might not be good enough. But if you get it via email, why would you not want to be transparent and give out your records to people that actually care enough to request them? Whether you have a dispute with them or not, my opinion has always been, yeah, go ahead and produce those records if you can. Okay, so we're going to skip. Email addresses and fax numbers are not accessible unless they're provided for the purpose of notices, and the owner actually says, yep, you can go ahead and disclose. Contracts and bids, anything that is not going to be performed within a year after the making of a contract for the purchase, lease, renting of materials or equipment, pardon me, to be used by the association, or contracts for providing services, all need to be in writing. If the contract exceeds 10% of the annual budget, you need to get competitive bids, unless there's no one else in the county or the area that actually does the work that you're looking for or provides that product. And again, I know I'm going quickly. You will get these slides after you submit your survey at the end of this, because we have about a minute left. And I will stick around for Q&A. Let's see. You don't need bids for professionals. You know what? We're allowed to skip entire sections. I'm going to do that. Assessments and foreclosures, you should be relying on your manager and attorney for anyway. But bottom line, there are a couple pre-suit notices that need to go out. They're good for 30 and 45 and 45 days respectively. Interest is owed on unpaid assessments no matter what. Late fees depends whether you're sitting there with that in your governing documents. That can be the max of $25 or 5% of each installment, not necessarily each month. So if you have quarterly assessments, that doesn't mean you can charge a late fee of $25 each quarter. The attorney's fees and costs are automatic and due from the owner, and we won't be able to get into some of this, but good news, we do have an assessment collection webinar that's also available on our website, which allows me to kind of skip some of this without you kind of losing out. Insurance is another one. Maintain adequate insurance. That's all you're required to do. What is adequate depends on your community. You might go by your management's expression of what is industry standard. We talked about directors and officers liability insurance. Make sure you have that. Fidelity bonds, an association needs to maintain insurance or fidelity bonding of anyone that controls money of the association. So make sure you comply with that. The Fair Housing Act, we've also got a webinar on that I mentioned earlier regarding service animals. So watch that one. That's another hour that we could get into. But bottom line, you don't want to ask questions about whether someone has a disability if it is visibly obvious. If someone's walking with a cane, they clearly have a disability, whether it's a blind walking stick or something else. You can obviously tell that they have a disability, which is either blindness or a physical ailment that doesn't allow them to walk like other people. So you can't ask what that disability is. But there's a lot more that goes into those FHA and Americans with Disabilities Act issues. So you're going to want to follow up with your attorney after you even watch that course that we have available. Recalls are highly technical procedural matters. When it comes, you really need to stop whatever you're doing and get everything over to your attorney, because it can be an all-day process for multiple staff and attorneys to review and verify whether any of the recall ballots or the recall documents altogether could be invalid. And if it is invalid, that is really what we're looking at is, was it done procedurally correct? Again, a recall is not the director did something wrong. It's they want the group that signed off on the recall wants a different person on the board for whatever reason, not wrongdoing, just because. But the reason that I say get this over to your attorney right away is because within 5 business days after receiving the recall written agreements, the board needs to actually hold a meeting and decide whether to certify, meaning approve the recall, or reject it, in which event someone might file a lawsuit or a petition for arbitration to decide whether or not the recall should stand. I've flown through a lot of this, which I fully acknowledge. The last thing that I'll mention, you can't file a recall petition or have a court actually or an arbitrator decide whether a recall is valid within 60 days before the next scheduled election, because that would make no sense. There's going to be an election anyway. Why would you bother? Okay, so Q&A. Jeff, if you can jump back in and go for it. I don't know if we've got any already, but I'm ready.
Debbie asks if you can go over the annual meeting accepting nominations from the floor as an HOA board member. Is that something that's permissible?
So
for an annual meeting?
It depends what's in the governing documents. If your governing documents don't say that nominations can be taken at any time, then they can't. And you might have a procedure in place that basically limits when those nominations can be made. Usually that's going to be via something similar to the condo procedure that I mentioned earlier, where you have a certain deadline when people need to nominate themselves. Usually that's going to be 40 days in advance of the meeting, which is the date that the statutes and the Florida Administrative Code required in condo world. But your governing documents may provide different timelines. So what you're going to want to do is look at your bylaws and see what the process is for holding your election, scheduling your election, giving notice of the election. That's where that answer is going to come from.
Okay. John, going back to your animals and condos, this is not the topic for today, but I will mention that in a couple of weeks, early August, Emily Gannon from our firm in the Pompano office, is going to do the FFHA assistance animal or pet class. I know you're on our mailing list, so you'll get that email, but it's also on our firm calendar. Let me just show everybody right now real quick. If you go to kbrlegal.com, choose calendar. I usually like to go to the month tab so you can see it by the month. Go to August. And over here, we'll be adding more in the coming days, but over here, we already have the assisting animal or pet. Click on that, your window opens up and your registration link is right within that calendar, and it'll take you to the Zoom registration. And that'll answer more than what you're asking for. We have, like Alan said earlier, we have an entire class devoted just to that. And while we're at it, to look at some of the past courses and webinars that we've done that Alan referenced earlier, also on our website, resources, webinars and videos. And here you go. Here's a bunch of the videos from the past, and they'll just keep going and going. We have about 150 of them and counting on here. But remember, they're for informational purposes only. Viewing them on demand will not get you credit or a certificate, nor should even this course live should not be considered as legal advice. I always consult with your association counsel if you have any questions or need some guidance, some official guidance. Okay, the next question from Jeff, spelled with a G, not from me. If a person had a felony 23 years ago and states that all of his or her civil rights were restored, what needs to be done by the board? Can they run? Can he or she or they run?
There's really nothing that needs to be done by the board unless you want to run a criminal background check, if that's part of your process of screening new members or new tenants. Bottom line, if it was 23 years ago, you just need, you can ask them, were your civil rights restored at least 5 years ago? And if their answer is yes, and you don't want to do any further investigation, you really don't have an obligation to. So yes, the only reason I even mention asking about it under the circumstances of, well, it was 23 years ago. If it was a felony, I don't know how long they were supposed to be in jail and how long they might have been on probation versus having their civil rights restored.
Okay. Let's see here. Could we have a closed meeting? Okay, I guess we'll CMA. Alexandra asks, can we have a closed meeting to choose and discuss about a new management company, or does it have to be an open meeting, including the CMA?
Your CAM never needs to be invited to any meeting you're going to have. I think that's probably the CMA was supposed to be CAM. They don't need to be invited to any meeting. So it's not necessarily closed. You just, if you don't feel comfortable discussing that information in front of that individual, that's not, unless that person is also a member of your community, they don't have a contractual or statutory right to be in the meeting. So you could keep the meeting open without closing that off to the members, but not have the manager there. Now, when you ask, can you close it off in general? Probably not, because it's not an employee. If that was why you were questioning, can we close it to the members? That's not an employee. That's a contracted individual. And it's basically the equivalent of a vendor, even though it's a very crucial vendor to your community.
Let me ask you this. You're familiar, I know you're familiar with what I'm going to bring up. I was part of the management team of a large scale 55 and over, where we didn't have a management company. I was employed directly by the board of directors. The association signed my paycheck. The association's logo was on my paycheck. Is that any different?
Yes, very different, because then you are an employee of the association. That's the exact distinction that the statute makes. It's not a manager. It's not any other vendor. It is specifically if you are discussing with counsel regarding potential or existing litigation, or you are discussing issues regarding potential or existing employees of the association. So people that you are hiring directly is what we're talking about here, not vendors.
Got it. Okay. Well, you could just remember. Okay, Stuart is asking, is there a restriction on what you can discuss with a member regarding board business? I guess that's
No restriction, but I would be careful about discussing anything privileged because that discussion waives the privilege. When you talk about attorney-client privilege, discussing with anyone outside of the board, management, or the association's counsel waives that privilege, meaning that the other side that you are potentially suing or is suing you is now entitled to get that information, and so is everyone else. So that's the only concern that I would have when you're talking about decisions that are going to be made by the board or have been made by the board. That's all, I won't call it public record, but it's all part of the official records of the community. Any decision that it's going to be made will presumably be made in an open discussion. If it's not something that's going to be made in an open meeting, then yes, that's something that you can keep from any of the members that are asking you questions. You know, there's nothing wrong with saying we're going to be holding a closed legal meeting, or we're going to be holding a closed meeting as a board to decide that issue. And I'll be happy to let you know what the final decision was when it becomes part of the member meeting minutes, or I'm sorry, the board meeting minutes.
okay. Alexandra's asking, well, I know the answer to this one. I can play attorney on this one, and you could tell me if I'm right or wrong. How do we proceed if not all owners have access to email and we would like to inform about a board meeting? Is a simple sign installed at a common area sufficient? And I'm going to say, yes, you educate and Alan will correct me. I'm not the attorney, disclaimer here. You would need to educate your community as to where official notices will be posted. And for instance, my old HOA, when I was living in South Florida full time, had a sign on a post by the front gate. That was it. I mean, so is something like that sufficient?
So I'll clarify your point, but you're generally correct. So how do we proceed if not everyone has access to email? I want to clarify that point first.
Okay.
Not everyone having access to email is not really relevant. It's that not everyone designated an email address to receive to receive notices from the association.
They didn't opt in.
The fact that they've provided an email address, even if they've said, oh yeah, you can email me here, if they haven't provided it for purposes of sending association notices and clarified that point, you still need to post the notice.
Right.
Now, to your point, Jeff, you mentioned something that's actually not required, in my opinion. So the notice needs to be posted in a conspicuous location in the community. You mentioned as long as you've told everyone where that's going to be. I couldn't care less whether you told everyone where it's going to be. The purpose of having it in a conspicuous location is that everyone's going to see it if they're going throughout the community. So the reason that most communities will do that at the entrance is because you don't get much more conspicuous unless someone is a homebody and never leaves home.
Right. Okay.
But you don't have to, you don't have to say we're going to have it here, but you do have to have it be a designated location. So there's nothing wrong with notifying everyone, hey, here's where the notices will be posted going forward. I just don't think it's something that's required.
Okay. Just may make the board's life easier, right? If the community is aware of where they're usually posted, I would venture to guess.
Yeah, I agree.
Yeah. Okay, here's an interesting question here. Justin asks, can a member post a board meeting? I guess member would be an owner. Can a member post a board meeting or a clip of a board meeting, I guess a video or audio piece, to social media without prior approval from anybody?
So without context of, what the hey, look at these idiots and what they're doing, without that kind of commentary, I don't really see anything wrong with it. The members are authorized to record all of these meetings. There's no statute that says what they can and can't do with that recording, but I would have concerns about it and would want to look deeper into that. Frankly, it's not an issue that's ever been raised to me before. Whether or not someone can go ahead and post that. I know they're entitled to record it. They're entitled to have the recording. What they do with the recording afterwards may be a different story.
Yeah, who knows what wow. Yeah.
I candidly, I don't have a straightforward yes or no answer for that at this time, because it's not an issue I've ever been asked to research. And there's to my knowledge, there's no explicit law that says you can have and use this however you want. It's just you can have this. The presumption is it's for the purpose of referring back to later when you're deciding whether to come after the board or come after an individual, or, you know, make your own notes from the meeting. It's not intended for the purpose of just posting it on your Facebook page or Instagram site.
Okay. We're going to do two more questions. But before I do that, I just want to let everybody know that I just opened up the chat. Okay. The chat is where you will ask me, not Alan, if you have any technical questions or issues pertaining to using the evaluation, getting to the evaluation, or printing your certificates. So in the chat, you can let me know if you're having some issues, and we're going to do, okay, we had a couple more. What we'll do is I'm going to turn off the Q&A. We have the last 4 questions here.
Okay.
And I'm going to put them on a document here so I don't lose them. All right. And now let me disable the Q&A so that we don't run out of time.
So I'm going to start just, oh, never mind. I was going to start reading to myself. That's fine. Go
The
for
first
it.
one is, and this is from Jeff Allen, and that's interesting because you're Allen and I'm Jeff, but he spells his first and last name differently than our Jeff and Allen. Further to the felony that he brought up earlier about the person who spent time in jail, but never spent time in jail, I guess it was 23 years ago. We have a board member that did the background check on his own. Can we have that go through arbitration? Can we have it go through arbitration?
I don't know why you want to. I wouldn't want to go through arbitration no matter what the situation is, but I'm not sure what would be going through arbitration. Would it be to get access to the specific records you're talking about? I'm just not sure what we're referring to here. I don't know why you go to arbitration about that. You know, if the question is, do we want to actually have something that governs whether the individual needs to turn over that criminal background check, you can ask for it. But if we're saying this person never went to jail or never went to prison, then their civil rights were never taken away. So there's no issue here.
Okay.
So I'm just not sure what the question really is.
Yeah, Jeff, you have permission in the chat. You can clarify in the chat. Everybody else, only technical questions about the evaluation. All right. Another question from Jeff. If the majority of your members are off-site and attend via Zoom, do you have to post notice? Do you have to post a notice site? How do you post that meeting? I can't understand the
You
grammar.
normally would. So you still post it in the community. It's not your fault that they don't live there. Hopefully they've agreed to accept notices via email, so you can send them the Zoom link. But when you're posting notice in the community, you just put to be held via Zoom. Here's the login credentials.
There you go.
Easy enough.
Another way around that is you can have
Go on
people.
there just as normal.
Yeah. And like for today's meeting, we had everybody RSVP. You know, it's not something you have to do, but I guess for a board meeting, you can send also an RSVP thing, and it automatically send out reminders, the Zoom join links, the whole 9 yards. That's a little fail safe you can try. See, technical, not an attorney, but I can give you technical stuff. Larry is asking, okay, I'll show you how to do the presentation afterwards. Alexander asks, could a meeting vote be adjourned to catch more votes after the first outcome of the voting was announced?
Not after you've announced the outcome.
Not after you've announced the outcome, yeah.
After you've counted the ballots, you've had your meeting, in my opinion.
Yeah. What if they did it incorrectly? What if they didn't have enough votes and they made a mistake and announced results, but then realized afterwards that they didn't get enough of the ownership to cast votes?
Start from scratch, schedule a new meeting, get new proxies. You don't want to have any challenge,
Right.
which based on the description, you definitely could have. You don't want to have that challenge be valid if it's brought. And if you've done everything, whether you intended to or not, whether you did it right or not, there's a potential challenge I can see there to, you know, just reusing those proxies, because it's not an adjournment of the meeting. You held your meeting, whether it was the right way to do it or not.
Got it. And then Jeff clarified his question in the chat about Zoom. Does it have to be on an on-site area? And it's yes, whether the meeting's in person or not, you have to post the meeting is happening, whether it's in a clubhouse or on Zoom, correct?
Correct.
Okay. Just did one of those last night for one of our associations. Everybody was away and the entire meeting was on Zoom. So there you go. But they still had to post it on their bulletin boards, in addition to the emails that go out and everything. So Alan, great job once again. I'm going to hang out. Before you go, and before I explain the evaluation and slides one more time to everybody, please tell everybody how they can reach you, and if they have any other questions, what they should put on the evaluation for you.
Sure. So to reach me, it's AS, my initials, at kbrlegal.com, just our website. We try to make it as easy as possible so no one has to write Schwartzide. You can call me at our number and reach literally anyone in our office at 954-928-0680. And if you want me to reach out to you, either regarding an issue that you have, or hopefully also regarding potentially our firm representing your community, there is a checkbox on the survey that Jeff is going to send out, or that actually he already has sent out via the chat, that you can click through and complete. And if you check off that box that says, yes, I would like to be contacted regarding potential representation, you'll hear from me as soon as Jeff gets me all those survey results, probably Thursday, Friday of this week. So you might hear from me Monday at the latest. But again, I welcome anyone that has any questions or is interested in working with our firm to just reach out to me directly rather than wait for that. And I appreciate everyone being here today. I know it's a long class and I probably went longer than I should have by about 2 minutes, ignoring the Q&A. But Jeff, appreciate your help. And again, appreciate everyone's attention and y'all for being here. And Jeff, you go ahead and do your thing. I'm going to jump off and take a breath now.